Good morning, Ms. Bertie. Are we ready to go?
I'm good, thank you.
Good.
Good morning.
Thanks very much. Yes.
Good morning, Commissioner, and thank you. Before we call the evidence of Ms. Tasha Bertie, who's our first witness today, can I introduce the representation that is present in the room and remotely? On behalf of the Attorney General and the elected ministers, we have Mr. Hussein Hairi, who is attending remotely, and Ms. Lauren Peaty, who is here in person. And on behalf of other members of the House of Assembly, we have Mr. Richard Rowe attending remotely as well.
Good, thank you.
Ms. Bertie, thank you very much for making yourself available to give evidence to the Commission this morning. I understand that you would like to make an affirmation, is that right?
Sure.
You should have in front of you the words of the affirmation. There's no need to stand, but could you read the words of the affirmation out now, please?
Certainly, thank you. I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. For the Commissioner, can you confirm your full name, please?
Tasha Carvin Bertie.
And is it right that your professional address would be Sea Meadow Building in Road Town?
That's correct.
You will see just to your left that there are 4 lever arch file bundles there. There's no need for you to open any of them, but we will probably be looking at various documents within those bundles as we go through your evidence, all right? The last thing just to ask you to do, and that's just to remember to keep your voice up.
Certainly, thank you.
I think that you'll notice that there's a microphone in front of you that won't amplify your voice, and both you and I are going to have to speak up because it's important that the stenographer, who's also attending remotely, be able to hear both of us. And so if speaking more loudly than usual is probably something he would welcome.
Okay.
Could we start with a little bit of background, please? It's right, isn't it, that before taking up your current role as Acting Permanent Secretary, you were a Deputy Secretary in the Ministry of Health and Social Development?
That's correct.
Taking that into account, could you just give the Commissioner an outline of your career in public service up to the current date?
Okay, certainly. I've been employed as an employee of the Government of the Virgin Islands since December 10th, I think it would have been 1997. I've worked as a guidance counselor. I've worked in the Ministry of Education as Assistant Secretary. I've worked as Deputy Secretary. I've worked as Deputy Secretary in the Ministry of Health, as well as Acting Permanent Secretary in various instances over that period. My service has been, I think it's going on 24 years this year since I've been in a public service.
And so have you taken on the role of Acting Permanent Secretary on more than one occasion?
Over the period, yes.
And you're presently the Acting Permanent Secretary. When were you appointed Acting Permanent Secretary in the Ministry of Health and Social Development?
I was appointed on June 7th, 2021.
And what does the role of being Permanent Secretary involve?
The Permanent Secretary acts as the administrative advisor, lead advisor to the Minister of Health and Social Development, providing policy advice and guidance in relation to matters of the ministry or key subject areas, and also helps to coordinate and manage the overall functioning of the ministry across ministries, as well as for the entire government service. Sorry.
Would a fair description of your role be that as Permanent Secretary, it's your job to supervise the ministry and the department?
In essence, yes.
But you do that, of course, under the direction and control of the minister.
That is correct.
Now, the reason that we're asking you to attend today to assist the Commissioner is in relation to statutory boards, which is the topic that the Commission is looking into at this point in time. And obviously it's in relation to the statutory boards that fall under the Ministry of Health and Social Development. And there are matters that we need to put to you, Ms. Bertie, because you are the present permanent secretary. I just wanted to give that some context. Now, you have made, in relation to statutory boards, on behalf of the Minister for Health and Social Development, the Honourable Carvin Malone, you've made 2 affidavits. And we're going to look at those each. If you pick up what should be marked as the Part 1 bundle. I'm afraid they're all big bundles, but if you could turn to page 254, please. You should see there the second affidavit that you've provided to this commission. I think so that there's no mystery about it. The first affidavit that you provided was not in relation to statutory boards. It was one that you provided when you were deputy secretary, and it was in relation to disclosure that was being made to the commission.
Okay.
It's not one that we're going to have to look at today.
Okay.
But I just wanted, for the purpose of the transcript, to explain why we're calling this the second affidavit.
Certainly.
Can you, if I just take you through to page 262, please? Could you just confirm for us that that's your signature?
That is correct.
And we can see that it's dated the 18th of June, 2021. The affidavit was prompted by a letter dated the 4th of June, which was addressed to the Honourable Malone, asking for an affidavit concerning those statutory boards that fell under the control of his ministry. Why was it decided that you should be the one to make the affidavit instead of the Honourable Malone?
From my understanding, I believe the information as the administrative lead at the time would be better presented by the permanent secretary, who would have had that information available.
And who was it that came to that view?
Who was it that came to that?
Yes, I mean, the letter was addressed to Honourable Malone. It gave him the opportunity to put someone else forward to make the affidavit instead of him. He suggested that his permanent secretary should do it. Commissioner was happy with that. But I just wanted to know how it was that it came to be decided that it should be the permanent secretary. You've explained that, and you referred to the administrative element of the work, but was it yourself who offered to make the affidavit, or did the Honourable Malone say, I think it's better that the permanent secretary do so?
I don't believe we had that sort of a discussion around who should do it. I believe, given the nature of the matter and the information that would have been requested, it would have been better served from the desk of the permanent secretary.
Thank you. Let's take a quick look at the exhibits that you've had. And we're not going to look at those in any detail now, but I just want to kind of explain them for the purpose of the record. So obviously, we're on page 262, which is the last page of your actual affidavit, and then you've exhibited a number of documents. And if we go to 265, please.
265?
Yes, please.
Sorry.
That is the first page of the BVI Health Services Authority Act of 2004, isn't it?
That's correct.
And you've exhibited the entire statute, because it's that statute that deals with appointments and the operation of the BVI Health Services Authority Board.
That's correct.
And that's a board that comes under the control of your ministry.
That's correct.
If we go to 294, we see there the start, and if you just leaf through the succeeding pages, Miss Bertie, you'll see that it's a table which has been prepared just listing stipend payments that have been made to board members.
Yes, sir.
Again, for the record, is that information that is held electronically by the ministry?
As far as I'm aware, yes, that is.
So was it compiled by officers under your direction for the purpose of this?
That is correct.
From electronic records that they hold?
That is correct.
If we go now to 396, we don't have to name anyone here, but this is the page, and it runs through 422, if you want to turn that up.
122?
Yes, please. I'll try and use your numbering system. So 422 is 396 is the first page of a set of CVs that you exhibit, and 422 is the last page of that set. And there are CVs of different individuals who became members of the board. That's right, isn't it?
Yes, sir.
Thank you. Let's turn back then to 254 and your affidavit. And could I take you to paragraph 3, which reads, at the outset, I should further say that in this affidavit where I mention a document, I do not waive any privilege asserted in respect of it unless I do so expressly. So the documents that we've looked at are a statute of the BVI government, a table of stipend payments, and some CVs. Which of those documents, if any, are you asserting privilege over?
Which of those? Sorry,
You say that where you mention a document, you don't waive the privilege asserted in respect of it. I just wanted to clarify which of those documents that we've just looked at are ones that you assert privilege over.
I have not asserted any privilege over any.
Right. And when you refer to privilege in your affidavit, what do you mean by privilege?
As I understand, it's information that was requested in relation to the information put before us, and it helps to support what you have requested.
How did you, in terms of making this affidavit, how did you actually come to make it yourself?
This was done in consultation with officers who work in the Ministry of Health, providing administrative support in completing the information. Research had to be conducted to gather the information in order to present the affidavit.
In terms of the writing of the affidavit, who was responsible for that?
One of the senior administrative officers assisted with that process.
Everyone will know that the government of the BVI is being assisted by the Inquiry Response Unit, which has been set up by a firm called Withers.
Yes, sir.
Were you provided with any assistance from the IRU?
The process, in terms of the preparation of the affidavit, that information would have been sent to the IRU during this process, and feedback was sought and received from them. So we may have gone over this affidavit several times before the final submission was made.
And in terms of paragraph 3, were you told to put that in your affidavit?
Mr. Rawat, with respect, if I may, I take it you're not trying to get into a question of legal advice privilege in your line of questioning to the witness, is that correct?
I'm not, but the privilege that it asserts belongs to the witness, not to anybody else. And the question, I don't think, is directed to legal advice privilege. It's directed to understanding how a sentence appears in an affidavit that this witness has signed, which the witness is struggling to explain.
Well, and in the circumstances, Mr. Hire, in which she's given evidence that no privilege is asserted.
Yes, Commissioner, but the content of her discussions with regards to lawyers in the context of this specific point seemed to be where Mr. Rawat was going with his questioning.
Can I join? No, just one moment. There's a sentence in paragraph 3 which the witness can't explain, but it asserts some privilege over something, and she now asserts no privilege. Are we to assume that she, off her own bat, put this sentence into the affidavit?
Commissioner, she doesn't assert privilege. She says that nothing that she says would waive privilege. She's not authorized to waive the privilege of the government over its documents. That's the point.
Right. So what you're saying is that there's no privilege in any of these documents, but if there were hypothetically to be privilege, she doesn't waive it.
She's not saying there is or there isn't privilege in these documents. She's just saying she's not asserted to waive it.
She hasn't said that in the document. She said that today in her evidence. No privilege asserted. It's just a mystery. Should it remain a mystery, Mr. Hirey?
I mean, I believe the sentence is that she does not waive privilege. She's not authorized to waive the privilege. It's the privilege of the government. And she simply said that she doesn't waive it.
Right. Mr. Hirey, are you claiming any privilege over any part of this affidavit or the exhibits?
It's a question of ultimately whether it's required to go through and deal with and get cabinet approval for the waiver of any privilege that might apply. As I explained yesterday, as a matter of priorities, we focused on the 42 affidavits that we've had to address. And so that exercise, given the time constraints, has not been done for this set of documents.
Fine. Okay, I understand that. And so if there is anything that privilege might attach to in these documents, Cabinet has not yet considered that. But is there any aspect of any of these documents in which privilege is raised?
There may be.
There may be. Over
yes.
what part of these documents may there be privilege? Just point to one, and then I'll understand the point, Mr. Hirey.
Well, as I've indicated, the analysis has not been done with respect to these specific documents. So I'm not in a position to...
You're a lawyer. Which part? Just point to any part of this in which there may be privilege. Just may be privilege.
I mean, I've explained the position. It's a general position that she's not waiving privilege. It's not a statement that there is privilege in the document. To be honest, I can't even actually open the document because it's so large right now, which is a source of frustration to many of us. We've pointed out that a document of this size is far in excess of the usual requirements of the court in the British Virgin Islands of 100 megabytes. It's a 2,500 megabyte document. So regrettably, I'm not in a position to even open it right now.
Well, with respect, Mr. Hirey, that's not my fault or our fault. But we now have a position, and this is going to arise with other witnesses. That's why I'm pressing it now. We have a document. We do not know if and when you, on behalf of the Attorney General, are going to pop up and claim privilege over something. It would be helpful.
I am told, yes, I'm sorry. I am corrected on this specific bundle. This is the bundle that Cabinet has approved for. So there shouldn't be any other issue on this specific bundle.
So even if there were anything in respect of which privilege could be claimed in these documents, this witness says there isn't, but even if there were, it's been waived.
For this bundle, yes.
Good. Thank you very much. Thank you.
Just to return to a point of concern, Mr. Hirey has said he cannot even open the bundle. We understood from correspondence, I mean, this complaint has been made by the IRU in correspondence that the bundle was too big, but they also said that they then split up the bundle. I don't know whether Mr. Hirey wants us to pause whilst he is provided with a split up version of the bundle that Withers prepared. Which then might allow him to follow proceedings more easily.
Yes, I think it was corrupted because even in the split up version it was too large. But leave it with me, and I'll get hold of I'll get access to it.
And perhaps if this is going to be an issue going forward, it may help if similarly Withers don't provide documents that are in excess of 100 megabytes. Can we return to Ms. Bertie? Ms. Bertie,
does that mean that all documents will be not in excess of 100 megabytes?
I don't think, Mr. Hirey, I was just making a request. I don't want to get into...
Is that just for Withers?
Well, can I stop you there? I don't want to get into a side discussion about this. I'd rather just limit the inconvenience that we caused to Ms. Bertie by trying to get her through her evidence today.
But Mr. Hirey, you're content to carry on as you are, although you can't get at the documents.
Yes, I think we ought to carry on.
Thank you very much.
Can we just return to that page, Ms. Bertie? this affidavit then, that at least that paragraph was not in your own words?
Paragraph 3?
Yeah.
I cannot recall.
Thank you. I'm now afraid going to make you just pick up part 4 of the bundle. Thank you. Now, if you should I'll just check the first page with you. It should be 3310.
Sure, correct.
If you go to 3943, please. This should be, if you've brought it up, the third affidavit that you've provided.
Yes, sir.
And the reason you had to provide this third affidavit was because there was a misunderstanding over what was meant by statutory boards and in terms of the bodies that fell underneath the ministry. And
That's
so
right.
you provided a third affidavit which deals with a second body, and that's the Public Assistance Committee, isn't it?
That's correct.
Again, just to go through briefly what you've also exhibited to your, before we do it, can you just go to page 3949, please?
Could you repeat that?
3949.
49. I'm with you.
That just confirm for us that that's your signature.
That is correct.
It's an affidavit dated the 3rd of September 2021. You have at 3952 set out an index to the exhibits. And if we just summarize those, it comes to the statutes that relate to public assistance.
That is correct.
And you've produced the Public Assistance Ordinance of 1957 and then the Public Assistance Act 2013, which repealed the ordinance.
That's correct.
And then what you've also then put in is letters and instruments of appointment and CVs of persons appointed to sit on the committee.
That is correct.
I don't have to ask you the question about paragraph 3, which if we go back to 3943.
Paragraph 3.
The numbering in this one's different, actually. It's if you go to paragraph 1.4, we'll see that the same sentence appears, but no issue arises because Mr. Hirey has confirmed that there's no privilege being asserted over these documents. So we don't have to go into the detail of how that sentence appears in this affidavit. Can I just confirm, are you content that these affidavits should stand as part of the evidence that you give to this commission?
That is correct.
That's helpful because it means that I will only need to ask you some questions about some parts of it rather than the whole thing. Now, you were sent a letter as the permanent secretary in which notified you of potential criticisms that may be made. And you provided a written response to that. That's right, isn't it?
That is correct.
And are you also content that that response be considered by the Commissioner for the purpose of his report?
Yes.
Thank you. Well, to save you jumping around between documents, let's start off with the third affidavit and the Public Assistance Committee, please. Again, just for the record, can you confirm that in terms of autonomous bodies that come under the umbrella of the ministry, it's just those two bodies, the Public Assistance Committee and the BVI Health Services Authority Board?
That is correct.
I think as we go through, I'll probably call the BVI Health Services Authority Board the board, But I'll stick to calling this the committee, and hopefully we won't get the two mixed up.
Certainly, understood.
Now, other than that, there are no other bodies, yes?
Bodies in relation to?
Yeah, there's nothing else that comes under the ministry that is a statutory body that you haven't given an affidavit in relation to. It's just those two.
Just these two, based on the information that was presented to us.
And in recent years, did the ministry have any other bodies put underneath its umbrella?
Over years.
Well, we understand that, and the Commissioner has evidence that ministerial portfolios change. So a statutory body can be moved from one ministry to another.
Okay.
And that has happened in the current administration. So there has been movement around different ministries. Did this happen in relation to the Ministry of Health and Social Development? I
suspect, but to say I recall exactly what and when, I don't recall right now.
Thank you. Let's go to page 3944 then. And it's the first thing we need to ask you about is the process by which potential candidates for committee membership are identified and selected. And if we just look at what you've written there, it comes, and please expand on this if you think it will help the Commissioner. But it comes to this, doesn't it, that potential members of the committee are recommended to the Minister by either the Permanent Secretary or the desk officer dealing with that subject, or the Minister might make recommendations. And once recommendations have been made, the person is contacted by the desk officer or by an administrator assigned to help. And the purpose of that contact is to confirm if they wish to serve on the committee. And at that point, they are asked to provide their CV. Is that right as the first sort of step?
Yes.
And then what will happen is that a paper will be, or the CV will be reviewed. A paper will be prepared within the ministry, which was then circulated to the Financial Secretary and the Attorney General. And then does it then go to the Minister for final approval before it goes to Cabinet?
That is correct.
So appreciating the division between yourself as a public officer and the Minister, if you like, as an elected representative and an appointed minister, is it the Minister that makes the final decision as to who is going to be recommended to Cabinet?
That is correct.
Now, in this case, and the Public Assistance Committee, you don't ask for written references in relation to prospective members, do you?
References, meaning the curriculum vitae are provided,
well,
but not...
The CV is provided, but
right.
Someone may provide a character reference or a reference from an employer about them. Do you seek references from others about potential members?
Not in this instance for these individuals.
And what due diligence do you actually carry out?
With respect to this process, the Ministry of Health would usually, especially in instances where persons are being reappointed, instances of that sort, the Chief Social Development Officer would provide feedback in relation to persons who may have served on that committee prior and are able to then give support whether or not they should be reconsidered based on their attendance and participation in the process.
Again, it's just so that any members of the public who may be following these proceedings understand. Could you just explain what the Chief Social Development Officer's role is?
The Chief Social Development Officer is the manager of the Department of Social Development. That's one of the departments, key departments under the Ministry of Health and Social Development.
And that officer sits as an ex officio member of the committee.
That's correct.
And so that officer is in a position to report back to you as permanent secretary as to the degree of engagement of a member on the committee, how often they attend, what role they play. So whether they are in fact fulfilling the role of a member of the committee.
That is correct.
And that could influence a decision to reappoint someone to the committee.
That is correct.
But take it back though to not reappointments, but a new appointment or a first appointment to the committee. What due diligence do you carry out?
In instances where an individual would be considered or nominated for possible inclusion on this committee, the due diligence from my perspective would be carried out with the assessment of the curriculum vitae that are provided. These individuals may very well be discussed informally with the officers who have responsibility for administering this whole process. And that information would then be shared with the minister.
Could I just ask for clarification, if I may, Ms. Bertie? If you look at paragraph 4.3 of your third affidavit, so it's the affidavit that we're on, paragraph 4.3, which deals with this. What this says is that the recommended persons are selected from a cadre of known and established professionals who work and operated in various sectors as noted in the Act, because the Act sets out the sectors from which candidates should be selected. So these are the recommended persons, so that we're ready to go. Then, in compliance with the condition that persons must be fit and proper for the role as stipulated in section 3.2b, it's standard practice of the ministry to request persons to provide their curriculum vitae, contain background information on work history, professional and educational achievements for the purposes of drafting the cabinet paper. So generally speaking, when do you ask for the CVs? When do you ask for the background information from a candidate? This suggests, and this doesn't fit in with your evidence, and I think I may have got the wrong end of the stick from this. This suggests that the curriculum vitae are asked for quite late in the process when you're preparing the cabinet paper.
It would be during that process, yes.
Right.
We would usually, as this is outlined, individuals may be asked, once they're nominated, individuals would be asked to provide their curriculum vitae. At that point, as this is suggested, the information would be reviewed based on the stipulated criteria in the Act, to see how best these individuals, if they do fit the gamut of what's expected based on the Act.
So the curriculum vitae, they're asked of all of the candidates, is that right? Or only the candidates who are selected?
All of the persons who may be nominated for consideration are asked to provide their curriculum vitae.
And then that all goes into the process of the assessment of the
That's
candidates.
Correct. That's correct.
To come up with the recommendations.
That is correct.
Yes, thank you very much.
Can I take you back to 4.1b?
4.1b?
Yes, please. If you look at A and B, and we've summarized it, but the process then seems to be that, and you've used the word nominated, but it's in your affidavit, it seems to be recommended, that recommendations are made before CVs are collected. So you only approach people who have been recommended and ask them first, do you want to serve? And second, if you want to serve, can you show us your CV? That's right, isn't it?
I don't think that's what I'm saying. Ask the question again, if you don't mind.
All right, well, let's better easier. I'll just read out what it is you've written in the affidavit. The process by which potential candidates for board membership are identified and selected is described below. A, persons are recommended to the minister by the permanent secretary or the desk officer for the subject, or the minister might make recommendations in accordance with section 3.2b of the Act. B, the persons recommended are contacted by the desk officer for the subject or an administrator assigned to ascertain if they wish to serve on the committee. They're provided with copies of the relevant legislation at this stage and are requested to provide their curriculum vitae if they consent to serve. The curriculum vitae is reviewed to satisfy the interests of the ministry in filling vacancies on the committee with persons possessing the requisite knowledge, experience and expertise in accordance with section 3.2 of the Act. So what I read that is that the first stage is identifying people to approach, and that's the recommendation stage. The next
recommendation or nomination.
Fine. Okay, recommendation or nomination stage.
Okay.
Let's agree. Those are your two words. Recommendation is your word. Recommended is your word. But the next stage is to approach those people and ask them if they wish to serve. And if they say yes, then you get the CV.
That is correct.
So people are nominated before you get the CV.
People are nominated or recommended before we get the CV. So in the process of the nomination or recommendation, I could say, for example, and there may be an instance where an individual is allowed to see or have seen the legislation, and after that process, they do not wish to be considered.
The effect is that you have a pool of people who are the recommended or nominated pool, who you then approach. That pool can become smaller because some of them might say, I don't want to serve on the committee.
That's correct.
But those that do give you their CV, and it's from those CVs that you then continue with the process, isn't it?
That's correct.
Now, my first question was directed to how, when I asked you what due diligence do you undertake, what is the process by which, or can you give more detail, the process by which that first pool of people recommended or nominated is identified?
I would say, going back again to the same section that the Commissioner mentioned in 4.3, if I may.
Yes.
Recommended persons are selected from a cadre of known and established professionals who work in various sectors, as noted in the Act. So from that information, of course, the Act would specify the particular areas, whether pastors, teachers, psychologists, counselors. There's a list of individuals or professionals that should be considered or can be considered for that role. Of course, in our selection process, as you've termed it, we can definitely find a cadre of individuals within the Virgin Islands community that may fit any of those areas.
But it's an internal process, isn't it? The discussions between public officers and the minister, is that right?
That would be correct. Or between the desk officer and the permanent secretary.
So it's wholly internal within yes, the ministry.
That is correct.
Right. But taking you back to the 4.3, what is meant by known? Known to who?
A cadre of known and established professionals.
Yes. Let's split that down. What is meant by known? Who knows them? You're
aware of them.
But who is the you?
That would be the officers of the ministry, the permanent secretary, the minister.
And what is meant, what's the definition of established?
By my definition, I would say persons that are or have built a rapport in the particular areas over a period. Established means working in the service, working in the various areas within the community for an extended period.
Within the professions that are listed in the...
That's correct.
I think it's a good time just to look quickly at the Act at those various areas that you mentioned. It's at 3964 in that bundle, Ms. Bertie. You should be at section 3. I think the section 3.1 establishes the Public Assistance Committee, and subsection 2 then says it comprises not less than 7 and not more than 9 members appointed by the minister.
I'm sorry to interrupt, Mr. Rowett. Before we get to this, these questions are important, but it would help me, Miss Bertie, if you just helped me to understand very briefly the system that we're talking about. I mean, the committee is responsible for the public assistance fund, but could you just briefly, in a few sentences, set out how that works? As my understanding from the ordinance and the Act is that the committee's been in existence in some form or another for a long time, since 1957, I think the ordinance was, and then, as it were, revamped by the Act. But the Act, as well as establishing the committee, which oversees all of this, sets up a public assistance fund and also sets up the framework in which the fund is distributed, if that makes sense. Obviously, there are regulations underneath it, but it sets out the sorts of hardship to which the fund responds. Is that more or less right in terms of the scheme?
That is the scheme of the public assistance program.
Yes.
Based on your understanding.
Yes.
That is correct.
Yes. So it's a government-funded scheme. So presumably get an allocation of funds.
The program is set up where persons who are vulnerable.
No. So I'm sorry. We'll come to that, because that's where the money goes to. But where does the money come from?
The government.
Yes. So the government gives the fund and the program an allocation each year.
That's correct. So it's budgeted every year.
So it's budgeted every year. That's where, as it were, where the money comes from. And then the Act, as I understand it, sets out a framework. It's only a broad framework of where the money goes to, the sorts of hardship that
qualifiers, yes.
to which the fund responds. And the committee then is, because there's a requirement that any applicant puts in a reasonably detailed application form with income and needs and lots of other information, and then the committee look at the application form and then respond to the application form from the fund if it falls within the criteria, and no doubt in the exercise of some discretion. Is that more or less right?
I'm not as intimate with the process, but I believe you've captured.
Yeah, I mean, just the overall thing.
What
yes.
the general consensus is with that process.
And the Public Assistance Committee oversees all of this, all of this process, the mechanism. The
committee would be a part of the process to evaluate applications and so forth. The overall processing of it would be done by the department itself, headed by the Chief Social Development Officer.
Right. So the committee oversee that process, which is done by individuals within the department. Oversees,
evaluates the applications that come into the department.
That's really helpful. Thank you very much. Yes. I'm sorry, Mr. Rowett.
If I take you back just to your affidavit, please, and if we go to 4.6.
Sorry, we'll finish with the section of the Act.
I think we paused there. We didn't. I'm not. I've lost.
This is my fault because I interposed with just some questions about the overall scheme.
I think I'd introduced it. So thank you for that, Ms. Bertie. If you go 3964, please.
3964.
Yes.
Sure.
So to recap. 3.2 says the committee shall comprise not less than 7 and not more than 9 members appointed by the minister by instrument in writing with the approval of the cabinet as follows. And it, as you've mentioned, the Chief Social Development Officer sits ex officio on the committee. And then you have not more than 8 other persons from among persons with knowledge, experience and expertise in medicine, law, accounting, nursing, social work, or persons representing academia, the religious community, or any other fit and proper person. So that seems to give scope to appoint someone who is a fit and proper person, but doesn't come into any of the other categories. That's right?
That is correct.
If we go to 4.6 now, which is going back to your affidavit at 3945. You were asked, do you consider whether the candidate is of good character and or a fit and proper person? If so, how is this determined? And you responded, the ministry in good faith judges the credibility of persons based on the following criteria: good standing, professional background, qualification and educational background, notable work and service within the community in compliance with section 32B of the Act. And that's the section that we just read out. Now, those appear to be the criteria that you apply. Where are those written down?
Where are?
Yes, you set out that when you're selecting people for the committee, and assessing a candidate, those are the criteria that you will consider.
That's correct.
So where are they written down?
I would say it matches the stipulations outlined in the Act. We are guided by the Act.
The wording that you have here doesn't appear in the Act.
I understand.
And you have that broader, you can, for example, appoint a fit and proper person who is not a nurse, not a social worker, not an academic.
Okay.
And so my question is that you've identified the criteria you write. Do you have a separate policy written down saying that when we consider candidates, these are the benchmarks that we will consider them against?
There's no written policy outlining that information.
And so where do those criteria come from?
Where
do the criteria come from?
As if we're looking at this, as the stipulations outlined in the Act, a fit and proper person, again, this is just a matter of interpretation. It's relative based on my view. We are looking for good individuals within the community, professional, qualified in whatever fields or expertise they may have had some sort of interactions in certain areas within the community as community-minded individuals. And we simply look at individuals in good standing based on the information that they will provide. We don't have it written anywhere in any policy. So as you're saying, the Act is what we would be guided by. But for the purpose of your question and our response, we have done that based on a number of credible areas that we would look for. Persons in good standing, person with an outlined professional background and relevant qualifications, whether educationally or not, notable work experience, and very community-minded individuals.
I mean, you've appreciated the difference in wording between what you've set out in your affidavit and what's in the Act.
Right.
And so that we can understand the criteria. I mean, are these the criteria that you apply as the acting permanent secretary?
This is what I would say, yes.
And is this the guidance that you give to the public officers who work to you?
This is what I would say, yes.
When they are assessing or considering candidates.
Right.
So
and based on your question, it's not something that we have written anywhere, but if we're looking for persons, any other fit and proper person, those are some of the things that we can look for in those individuals.
The question is not as important as the answer, but it's trying to understand the process by which you in practice operate as the ministry. And is it the case that since you have taken on the role of acting permanent secretary, these are the kind of criteria you expect to be applied when candidates are being considered for the Public Assistance Committee?
I would answer that question by stating what I am aware of in terms of what we do in the ministry. And from my experience, the Ministry of Health has always attempted or made attempts to look at individuals in a cross section or across the diaspora of the BVI persons with notable work experience, professional qualifications, as well as good and regular standing within the community who can add to the elements of the importance of the role that they're being selected for.
And would you say that what you've identified as 4.6 is what the ministry would use or as the definition of a fit and proper person?
That is correct.
You've referenced how important the Act is. So is the approach of the ministry to treat the Act as setting out the framework for recruiting and appointing?
Could you repeat that? I'm sorry.
Of course. You've explained before, and you've referred to the Act, and that what you do is you're guided by the Act, aren't you?
That is correct.
So that gives you the framework for how you should approach the recruitment and appointment of members of the Public Assistance Committee.
I believe that is the sole guidance tool that we should be using in all elements. The law is the law.
Could I just ask one question? I think it's related to this. If you look at 4.4 of your affidavit, just above where we've been looking.
4.4, yes, sir.
And this is about the criteria for appointing a person to the board. And you say that the criteria for appointing persons to the committee is stipulated under section 3, which we've looked at. That's fine. This is supplemented with adopted practice implemented by the ministry as described in the answer submitted for question 9A. This may be entirely me. I can't find a 9A, so it may be in a different document or a typographical error. Or
Could be a typographical error. It could probably be a typographical error.
I'd agree with Miss Bertie, because I did check across to the letter of request that was sent to the Honourable Malone, and it doesn't have a question 9A, and I've checked it again.
I mean, as I say, it's not a trick question. I just wondered what you were referring to there. I don't think it is question 9. I think it's a typo. But Commissioner,
I would have to do some quick skimming, but I really can't pinpoint exactly.
I mean, from your answers in relation to 4.6, it may be a reference to 4.6. This is supplemented with adopted practice implemented by the ministry as described in the answer submitted for. And 4.6, the way you've given your evidence suggests that in practice, although this isn't written down, in practice, these are the sort of criteria or characteristics that you personally look for and the ministry looks for.
I would accept that.
Yes. So unless you come back to us at any point, I'll take it that that's what's meant.
Certainly.
Yeah, and that makes sense.
So that would be supplemented. This is supplemented with adopted practice implemented by the ministry as described in the answer submitted for question 4.6.
Exactly. And that makes sense. So you make sure that the statutory criteria are complied with, but that's supplemented by the practice as set out in 4.6.
I can accept that.
Thank you very much.
Thank you.
And Ms. Bertie, if just for completeness, let's look at 4.7 quickly, because what's taken into account, you were asked, are convictions / spent convictions taken into account? And you said convictions are taken into account during the appointment process, since a conviction disqualifies a person from being a member. And again, you cross-refer to the Act itself. Does that extend to spent convictions as well?
I don't think the Act speaks to spent convictions.
So what guidance do you have as to what kind of convictions you need to take into account?
Well, at least from my understanding or recollection, I don't know that we've ever had any instances where an individual who may have been convicted, whether spent or not, has actually been considered.
Yes. But I mean, the Act makes it clear that what it says is that the minister may by written notice remove a member other than an ex officio member from office if satisfied the member has been convicted of an indictable offence or any offence involving.
What page are you referring to?
3966.
That's 833.
That's what you referred us to as the part of the Act that you relied on for your answer, which says that convictions are taken into account during the appointment process. So is your understanding that if someone was bold enough to apply to you with a conviction, that would mean that they wouldn't succeed during the appointment process?
As I said, I don't see that ever happening. As it is, the legislation already disqualifies that individual. And as far as I'm aware, we've never had any instance where an individual who would have been convicted in any form would have been considered for this committee.
I certainly don't want to drag you into law,
Okay.
Ms. Bertie, but it doesn't quite answer the point for this reason. Section 8.3 concerns somebody in office, and these are the circumstances in which the minister may remove that person.
Okay.
And so if they commit, say, an offence involving dishonesty, then the minister can remove him. So spent convictions don't come into it.
Okay.
Spent convictions are, as it were, old convictions. But if this is fair, I think your response to Mr. Rawat was that in terms of spent convictions, you haven't brought your mind to bear on that because it's never happened.
That is my position.
Yes, thank you.
You said a few moments ago, Ms. Bertie, referring to the importance of the Act in terms of this process, that the law is the law. The Act doesn't say, does it, that you can't advertise for appointments to the Public Assistance Committee?
It does not.
And you could advertise by setting out the criteria and the requirements of the role and inviting applications, couldn't you?
I agree that can be done.
And it doesn't say that you are not allowed to ask for CVs before you make recommendations.
It doesn't say.
You could ask for CVs at a much earlier stage. Is that right?
We can access CVs at any stage in the process.
And you could, as part of your process, ask for references for those who express an interest.
That is certainly something that can be considered.
Because what I suggest is, if you took steps like that, wouldn't you widen the pool of suitable candidates?
It certainly would, I suppose. There might very well be persons who would consider and would like to be considered, as well as there might very well be persons who don't apply. It all depends. Because it's not something that we've ever done. So I can't speak to something that we've never done.
Because what you're depending on is that someone exists within the knowledge of the desk officer or the permanent secretary or the minister. And then that someone can be described as known and established. And that leads to the recommendation. What the system doesn't allow for is the member of the public who thinks they'd like to give something back to the community, they'd like to play a role, and but they perhaps don't know how to do it. And if you were to take that process, people might be more encouraged to come forward and play a part in the community.
I believe it is something that can be certainly thought about as we've gone through these processes, especially even in preparing this information. It's something that we recognize can be considered moving forward.
Do you anticipate any downsides to adopting that course?
I've not given it much thought, but I can certainly see where there might be some disadvantages to it, where persons don't necessarily apply for consideration, if you understand where I'm coming from. If it's advertised and then there are actually no applications that are submitted, what do we do then? You
could re-advertise.
And the same thing happens.
And then right. you could, I mean, that's a hypothetical.
Right, that's what I'm saying.
But the reason I put the proposition to you is it is a way of which you could widen the pool.
I agree.
You won't know whether it works until you try it.
I agree.
Can I just take you quickly to 3947?
3947.
This is a table that you have provided as part of the affidavit, and it's it's the composition of the Public Assistance Committee over the past 3 years. And can we summarize it like this, that essentially the committee has remained the same, the membership was just reappointed, is that right?
If we're going on the basis of the information presented, yes.
Yes, well, I mean, it's your affidavit and you signed it. I'm asking you just to confirm the detail.
Based on the information presented, yes. They've all been reappointed. They're all reappointments.
If we go back to 3966. We've looked at this already, but it's the circumstances in which the minister, and this is at 8.3, can remove a member. And again, I'm conscious the commissioner makes the point we shouldn't get you involved in too much law. But what 3 sets out, doesn't it? And I just want to confirm your understanding of this. Is that those are the circumstances in which the minister could remove a member other than the ex officio member. If those circumstances arise, then the minister has a power to remove that member, doesn't he?
That's correct, based on the Act, yes.
Yes, and the circumstances are that if the member has, without the consent of the committee, been absent from 3 consecutive meetings of which the member has had notice, and that information presumably could come from the social development officer.
Yes.
The second reason or basis on which the minister could remove a member is if the person is adjudged bankrupt and has not been discharged. The third is if they've been convicted whilst a member of an indictable offence or an offence involving dishonesty. And the fourth is if there is of unsound mind or is certified by a medical practitioner to be so ill as not to be able to properly discharge his or her functions under this Act. Now, those are the 4 stipulated bases on which the minister could remove a member. Is that right?
That is correct, based on the information in the Act.
Yes, and the Act doesn't allow the minister a general power to remove members from the Public Assistance Committee, does it?
I think the section is clear, the tenure of office and how persons can be removed. Those 4 points are listed there.
So you've referred to, I think, both the board and the committee as being autonomous bodies, and autonomous presumably from the ministry, self-standing bodies. Sorry,
What is the question?
You've referred to both the board, I think, and the committee as autonomous bodies. By autonomous, I assume you mean autonomous from the ministry, so they're self-standing bodies.
Okay.
Is that right?
Yes, correct.
And looking at this simply is part of the autonomy that the board has, isn't it? I mean, the minister can, let's put it in a more neutral way. An individual who is a member of the committee has security of tenure for their period, 2 years, 3 years, whatever it might be, and can resign, but otherwise can only be removed in the circumstances in subsection 3. That's part of the autonomy, isn't it, of the committee?
If you're saying that this does not give them autonomy.
No, I'm saying that this does give them autonomy.
Oh, okay. Yes, it does.
Because it gives them security of tenure. The tenure is only for the period of their appointment. But if their appointment is for 3 years, they cannot be got rid of in any way other than in section 8.3.
I think that's correct.
Yeah. So it reinforces the autonomy.
Certainly.
Yes. Thank you very much.
Thank you. Commissioner, unless you have any other questions in relation to the workings of the committee,
to go on to the
move on to a different point.
I think we should have a break. We'll have a break primarily because the stenographer needs a break from his work, just a 5-minute break. But we'll break for 5 minutes and then come back, Miss Bertie.
Thank you, sir.
Thank you very much. Good. I think we're ready to resume. Thank you, Mr. Wright.
Thank you, Commissioner. Ms. Bertie, thank you for coming back. And could I ask you now just to help us in relation to the BVI Health Services Authority Board, which I'll call the board from now on because it's a bit of a mouthful. That you dealt with that in your first affidavit, or the second one, to be fair.
Okay.
If we look at 265 then in that bundle, that's where you produce the Act. And that you've exhibited the Act to your affidavit. That's the governing legislation in terms of the process by which people are appointed to the board or indeed removed from it. Is that right?
That's correct.
Other than that, is there any written guidance or policy in the ministry governing the recruitment, appointment, or removal of those appointed to that board?
No, sir.
And so is it in the same way as we saw with public assistance, that you and those officers who work to you would look to the Act for guidance if you need it?
That is correct.
Could you turn up, please? Go to page 269. Just some questions about the appointment process. Now, 269, if you want to just turn back to the project, it's part of section 5, which starts on the preceding page. And if we look at subsection 3A, this deals with the appointment of people who are not ex officio members. And that is that what the board should have is no less than 7 or more than 9 members appointed by the minister with the approval of, and it says executive council, but it's now taken to be cabinet. From among persons with knowledge, experience and expertise in medicine, law, accounting, nursing, insurance, social work or other professions, and persons representing the BVI Chamber of Commerce and Hotel Association, academia and the religious community. So does that mean that the membership of the board has to reflect those specific fields that are set out in the Act?
I believe the stipulations are clear, yes.
Would it be deficient, therefore, if the board didn't have somebody on it with nursing experience?
It doesn't speak to any deficiencies in those areas.
But what you've got
You might, if we're sorry, if I may, if we were to count the various areas here listed, it's probably more than 9. So you can very well have an individual that, not an individual, or may have instances where you don't have a person with that background based on the stipulations outlined here.
And you can have a person who ticks more than one box. You can have someone who's nursing in academia. But my question was just whether the expectation is that you should have the spread that's envisaged by the Act.
I don't believe that would have been the interpretation intended.
Does that mean that you could have a board that's entirely medics?
I don't believe that's the intention intended.
What do you believe the intention of that provision to be?
It's about finding individuals with a cadre of specialties or areas that would lend to the process.
But what mechanism is there, if any, in place to stop the board ending up with a disproportionate number of members with a particular background, for example, law?
I suppose the question would be what mechanisms is in place to stop that from happening?
Yes.
I suppose it would be with the process that's entailed to select persons for that board. So in other words, if based on the minister at his discretion and the cabinet, if they recognize that there are individuals across the selection process that as you say, top-sided with just medical persons or just lawyers, then it's at their discretion to make that change or try to avoid such situations.
So you could have a situation where you have a board that doesn't have somebody on it with some sort of nursing knowledge, for example.
I suspect it could happen.
Now, if we look at 5.5, just it's on the same page, it's subsection 5. And so what the minister does is to recommend persons to be appointed to the cabinet for approval. Is that right?
Yes.
And so cabinet will, the persons put forward, 2 of them are nominated by the leader of the opposition, but the persons put forward or the cabinet can appoint ordinary members of the board and also the deputy chair. The additional detail in relation to the chairman is that requires the approval of the House of Assembly. Is that a fair summary?
That is correct.
If you go to 7C, which is on page, sorry, that's not 7C. It's back to your affidavit. Sorry, let me find the reference for you. It's page 255, please. And this is responding, Ms. Bertie, to a number of questions about the operation or the process by which members of the board are recruited. You say at C that there's no requirement under the Act that posts on the board be advertised. But it's right, isn't it, that neither the Act doesn't prohibit advertising, does it?
No, it does not.
And again, in the same way as I think you fairly accepted in relation to the Public Assistance Committee, the use of advertising would also widen the potential pool of candidates that you might have for the board.
Agreed.
And you can refer to both the Public Assistance Committee and this board if you like. But has the use of advertising been contemplated in the ministry at any time?
I believe it is being contemplated now that we've really gone through this process. It has been contemplated, yes.
Before then?
I can't speak to that.
How long have you been in the ministry?
Ministry of Health would be 2013. So that's
and in that time, you haven't come across a suggestion that posts for either the board or the committee should be advertised?
Not in details. It may have been a conversation, but not in any great detail.
Keeping to paragraph 7 at page 255, you deal at E with subparagraph E.
E. Okay.
Yes. And so what you've got and we've discussed is the minister making nominations. And you say at E, once candidates have been nominated, they are then requested to provide their curriculum vitae to the ministry for submission to cabinet and the House of Assembly accordingly. So this seems to parallel what happens with the Public Assistance Committee, doesn't it?
Yes.
It's after the nomination stage that you go and seek CVs.
That's correct.
So the choice of who is going to be nominated is made on information other than a CV.
Based on the stipulations outlined in the Act, nominations are put forward in consideration of the minister and the permanent secretary in their discussions.
So again, it's an internal discussion within the ministry between a desk officer, a permanent secretary and a minister.
Or the minister.
And again, the minister has the last word as to who will be nominated. From my understanding, and well, again, I was not necessarily involved in this process, but I believe at some point that is the final. Because it's the minister that has, under the Act, that has to make the recommendation.
Yes.
I'm sorry, there was a little too much overlap. Could you start the question and answer again, please?
Yes. I'll let Miss Bertie add any detail that she wishes, and then I'll ask my question.
Can you ask your question?
I'll ask my question instead. That's fine. I was putting to you, Miss Bertie, that the Act provides that it's the minister that must make the recommendations. And so doesn't it follow that the minister will have the last word as to who is going to be nominated to cabinet for appointment?
I think that is correct, a correct assumption, with the exception, of course, of the position for the chairman, which he must do in consultation with the leader of the opposition.
That's a fair point to make. But it also reflects, doesn't it, the distinction between a minister and yourself as a permanent secretary. There is a line that you cannot cross as a public official, isn't there?
I'm not certain.
Well, there are certain types of advice that you can't give a minister.
I'm not certain I understand the question.
Well, you cannot, can you, as a permanent secretary and a public official, give political advice to a minister?
No.
And so there are certain things, there may be certain things that ministers do, or certain areas of policy that they're interested in that you cannot assist with because it's political.
That is correct.
I was just using that as an example that there is a line between the role you play as permanent secretary or a public officer and the role of a minister. Okay. But it takes us back to the point that it is under the Act, the minister that makes the final decision.
That's correct, based on the Act.
Broadly, and there are some differences. I mean, there are some differences, for example, in the list of professions or the list of expertise in the Public Assistance Act and this Act. And also under the Public Assistance Act, there's a sort of general catch-all category at the end, fit and proper person, whereas in this Act, you have to fall in one of the categories and be a fit and proper person under Section 5(6). So there are little differences. But in terms of the process adopted by you and the ministry in identifying and putting forward individuals to fill memberships of the committee and the board respectively, they're broadly similar, as I understand it.
I think that is a fair assumption, and I would say not by me, but by the persons in the post of permanent secretary.
Yes, but it's for whatever reason the process is similar. That's not a criticism.
I believe that is a fair assumption.
Yes. Thank you very much.
What you've said and we're still on page 255, is that I think it's G, where you say there exists a practice based on the candidate's known standing in society, for example, whether he's employed, has good standing in the community, good reputation, etc., that is used informally when recommending nominations. And is that, it's the same situation as we discussed with the Public Assistance Committee. This isn't criteria that is written down, so that there is a listed set of criteria by which you all operate.
I agree.
These are factors that you would keep in mind when deciding what nominations, in your case, to put to the minister.
I agree.
And again, would it be fair to say that phrases such as known standing in society, good standing in the community, good reputation, are the factors that go to the definition or the working definition that you have a fit and proper person?
I think in summary they do, yes.
So I didn't catch your...
I said I think in summary they do.
Yes. Well, if there's anything you want to add to what criteria you use to define a fit and proper person and to decide a nominee, please do so.
Okay.
But in any event, these are the criteria and characteristics that are looked for.
That is the general approach used by the ministry, yes.
Thank you.
And it's open to the minister, isn't it, to reject any nomination that you might put forward as permanent secretary?
Again, I agree. That is the position. At the end of the day, the law allows the discretion of the minister with any appointee. The minister also has powers to recommend and as it says there in the legislation.
It's not, I accept it's not just down to the public officers to come up with names. The minister can put a name forward as well.
Yes.
But this is all just part of the internal and informal process that goes on.
Yes.
As to that process, so there is nothing, is there, in the Act to stop the minister from changing it? The minister could ask for CVs before names are put to it.
I agree, yes.
He could decide that even before names or individuals are put before cabinet, they should be interviewed.
I agree.
He could decide that there could be adverts made.
I think we've established that those are things that could be done, and it's all part of our observation, having gone through this process, that it would very well be something that would be useful moving forward.
Can you clarify one thing, and that's at your subparagraph E.
Subparagraph
E on that same page.
E, okay.
You will see there that it says in relation to the request to provide a curriculum vitae to the ministry for submission to cabinet and the House of Assembly. That would refer obviously to the chairman. You say they're screened by the ministry against information held by the ministry to verify that they do not breach section 1, subsections 1, 2, and 3 under schedule 1 of the Act. If we look at what that section says, if you go to page 286, please. Section 1 of Schedule 1 says that the appointment of the chairman shall be for a term not exceeding 3 years. Subsection 2 makes the same point in relation to the deputy chairman and any other members of the board. And 3 says that someone can be reappointed, but not for more than 3 consecutive terms. So when you say they're screened against information held by the ministry to verify they don't breach section 1, what are you trying to verify?
To ensure that they are not, there wouldn't be any breaches in relation to the sections that you've outlined. So in the event, for example, a person who is the deputy chair, or a person who was appointed under section 3 of the schedule 1, they're eligible for reappointment for 3 consecutive terms. So we have within the ministry a process where we call it our top paper, which outlines the persons that would have been sitting on various boards over the period, and it would show the periods under which they would have been there. So if a person is, let's suppose one of the board is up for reappointments and the minister wishes or the team considers to reappoint an individual to the board, we would have to ensure, based on Schedule 1, Section 3, any of the persons that are being reappointed under this Section 5.3a is eligible based on the fact that they have not served for 3 consecutive terms. So that's what
it comes down to, isn't it? That's actually the breach that you've got to look out for.
Exactly. So that's what that section G, as you've outlined, is it G? Not G.
It's your E.
E, sorry. That's what that is making reference to.
I mean, because a new candidate or new appointee,
new appointee wouldn't be checked against this because they're new appointee.
I'm sorry, please, there's overlap. Start again.
That's my bad.
I'm as guilty of that. I'm more guilty of that than you are, I think.
He is.
Ms. Bertie, let's clarify it this way. I mean, it doesn't apply to new appointees.
No, it doesn't.
What it applies to is what you have to check in terms of reappointing. I mean, the 2 things you have to look out for is to make sure that someone doesn't exceed their term, and secondly, that if they're being reappointed, they don't go for the 3-term limit.
That's correct.
At your F, you say that Cabinet and the House of Assembly have the discretion to request interviews and stipulate the appointment process. Could you just add a little bit more about that, please? Is that written down at all? that they have that discretion?
Cabinet and House. If we go to section 6 of the Act, again, I'm
Page 270.
270.
I think that may be a typo, actually. I think you're thinking of section 5.6. It starts at 269.
Okay. So what was your question?
It relates to the first line of that subparagraph, and whether it's written down anywhere that either Cabinet or the House of Assembly have the discretion to request interviews and stipulate the appointment process.
It's not written to anywhere in my estimation. I've never seen it written anywhere.
But what? So where does it come from that they have this discretion?
Again, Cabinet and the House of Assembly can dictate however they wish for a matter to be handled. It may not necessarily come in written form in this way. It might be after they've had discussions in the Cabinet setting and wish to have a matter returned to the ministry for further review or additional considerations for them to be able to make a decision.
In your experience, has Cabinet ever asked for interviews?
In my experience since June 7th, no.
Or since 2013? You've been there in 2013?
Not based on my experience, no.
And we're talking about the board.
Sorry.
And obviously the House of Assembly has to approve the chairman of the board.
Right.
To your knowledge, has the House of Assembly ever asked that the prospective chairman of the board be subject to an interview?
Not to my knowledge.
You go through to now your paragraph 12, which is at page 262, please.
Page 262.
You're dealing now with declarations of interest, and you say there's no written guidance given to members appointed to the board except as provided in the Act, and that you explain that they are given copies of the Act when they first come to sit on the board. What guidance does the Act give in terms of declarations of interest?
I'm not certain what specific sections may speak to that.
I mean, it's a small point.
Maybe within the section, what's this, Schedule 1, functions of the board. It might very well be implied in some of those areas.
I haven't been able to find it, but can we put it this way? As far as you're aware, is that there is no, other than the Act, there's no written guidance that would assist a member of the board in terms of declaring an interest?
As far as I'm aware.
And you go on, and this is at your paragraph 13, to say that there are no written standards for monitoring or assessing the performance of members of the board. Are they monitored in any way?
Again, from my knowledge, I suspect we we call the HSA authority would have a log in relation to attendance to meetings. So I suppose the minutes of the meetings would be a measuring tool by which they are monitored in terms of their attendance and participation in meetings.
But it's not, I mean, it seems to be a distinction that you draw in this affidavit with the board and the Public Assistance Committee, because you explained in relation to the committee that when considering reappointment, you will effectively get feedback from the ex officio member of the committee.
That's correct.
In this case, there doesn't seem to be any process at all by which you, as the ministry, with oversight of the board, get any feedback as to how the board is functioning.
In this instance, not to my knowledge.
Is that a consequence of the degree of autonomy that this board enjoys from the ministry?
I suspect, yes, it is.
Now, I've asked you, and you've answered me about the possibility of advertising, obtaining CVs earlier, and interviewing candidates. Now, leaving the board and the committee aside, is it right to assume that there are other processes or other areas of the ministry's business where you do that, where you advertise posts, you ask for CVs, and you interview candidates?
That would be for vacant positions within the ministry, yes.
So,
for employee positions.
Yeah, but it's a process that presumably permanent secretaries.
Yes, it's something that we do have to do.
And you're familiar with?
Yes.
Can I now just ask you to look at 286, please? This is taking us back to Schedule 1 of the Act. And if you go over to 287, Section 3, please. You'll see there that it says the minister, with the approval of, and here it's the cabinet, may by instrument in writing remove a member of the board other than an ex officio member from office, if satisfied that the member A has, without the consent of the board, been absent from 3 consecutive meetings of the board or for periods exceeding 1/3 of the regular meetings held in a year, is or become disqualified from being appointed as a member of the board under Section 5(7), C is unable or unfit to discharge his functions as a member of the board, or D is in breach of any conditions imposed upon his appointment. And Section 5(7), if you want to look at that, is at 270, and it says that a member is disqualified for appointment as a member of the board if he is a member of the Council Assembly, is an undischarged bankrupt or has compounded with his creditors, has been convicted of an indictable offence or any offence involving dishonesty, has, after being previously appointed as a member, been removed in accordance with Schedule 1, or has been certified by a psychiatrist to be of unsound mind. Now, although the wording is different, it is comparable to the Public Assistance Act, isn't it? Because the bases on which a minister can remove a member from the board.
I agree, that's a fair assumption.
And what there isn't is any other discretionary basis on which a minister can remove someone from the board.
I think that is fair.
Now, if you go back to your 257, please. You've set out again the composition of the board over the past 5 years. There's been a bit more change with this board than there was with the committee. But if we focus on those who are the most recent composition of the board, we'll see that with the exception of the very first person, the others, and it runs over into page 258, have terms of office. Sorry, it's with the exception of Mr. Hodge and Ms. Smith, but everyone else on the board, their term of office finishes on the 21st of June 2021. What has happened to the majority of the board?
What has happened? I don't understand the question.
Well, it's now the 7th of September 2021. So if you take the first person, they will cease to be a member of the board on the 21st of June. That's Dr. Venza.
I believe this board has been, a new board was recently constituted.
Was it recently constituted before the 21st of June?
Not to my recollection, no.
But is there power in the Act to allow people to continue after their term has expired?
I would have to verify within the Act right now, but I don't have that information off the cuff.
Well, I want to be fair to you, so could I ask just that you check two things, please, and if you can give an answer to the Commissioner via your legal representatives, and that is firstly whether the Act allows a member to continue beyond the term that they are set to serve, so effectively outside the instrument of appointment, and secondly, does the Act allow the Ministry to extend the time at which someone sits without going through the process that you've outlined?
I believe I can say the answer is no to both questions, but I can't speak to that right now from the Act directly.
Well,
I am aware though that this board was recently constituted. So there is a new chairman and deputy chairman and new members, some new members within this board, but I don't have that information.
Well, whatever information you can give us to the timing of that would be very helpful.
It would have been after this submission.
Yes, which I think was on the 18th of June 2021. So, I mean, we want the best evidence that you can give, Ms. Bertie. So if you need time to think about those questions, I'm sure the Commissioner will give it to you.
So, yes.
Can I take you now to a different bundle, please? And that's part 2 of the. Sorry, I'm part 3. I apologize.
3?
Okay. Could you turn up, please, page 3238. Do you have the page?
Sure, I'm with you.
Thank you. What we should have is a memorandum prepared by the Ministry. It's dated the 7th of May 2019, and the name at the top is Mrs. Natalie Faye Smith, which I assume is a member of your team at the Ministry.
That's correct, sir.
But if you go to the last page, of this paper at 3248.
3241 would be the last page.
Sorry, you're right. Yes, 3242, in fact, actually.
Okay.
The 8th of May 2019 appears as a date, and that's together with the Honourable Carvin Malone's name. I just wanted some clarification from you, just with how a paper like this would be prepared. So would it be right to say that it would have been prepared by Mrs. Faye Smith as a draft, which then goes to the Minister for approval?
I would say the information, or there would be discussions, informal discussions regarding the appointment of the board, and the fact that memberships may have been expired or on the way to being expired. And discussions would be had with the minister informally, as well as possibly in writing, whether via email, to him for consideration as to having reappointments or new members appointed. Once the recommendations are put forward by the minister, whether by the officer submitting names for consideration or by the minister giving recommendations or nominees for consideration, once that is done, then the officer would begin the process of preparing the paper.
So, not speaking, I'm using this paper as an example of the process.
Right.
So we've discussed and you've given the commissioner evidence about how the process works. So the next stage is to prepare this paper. That's what you've explained just now, isn't it? But my question is that although it is Mrs. Fahey Smith or Mrs. Foy Smith who prepares it, it's the minister who signs this paper.
That is correct.
So it becomes the minister's paper.
That's correct.
And the minister has to approve the contents of the paper. That's the point, isn't it?
Yes.
And then the minister then takes that paper to cabinet. Is that right?
Right. So what I outlined just now would be the process even before it gets to this draft.
Yes. I think we've understood the process. You know, that there's an internal nomination process. There is then a process of obtaining consent and obtaining CVs. There is then a review of the CVs, and then that's at the point at which this preparation of this paper may begin.
I think we're speaking from the same tongue sheet.
That's very good of you to say that, Mr. Bertie. If I ask you, though, to go to 3271 in the same bundle. Just to put it in context, if you turn up 3249. Yes, that's the first page of a minute of a cabinet meeting number 14 of 2019. Do you see that?
Yes, sir.
Now, I accept that as a permanent secretary in the Ministry of Health and Social Development, you would not ordinarily see cabinet minutes.
No, sir.
You would, I think it's either you might see an expedited extract or you might see a memorandum that emerges from cabinet. Is that right?
I will see an expedited extract or a memorandum. That's correct.
Now, if you turn to 3271.
Yes, sir.
Are you okay to carry on?
Yes, sir.
This is where a paper, it's not the paper that we were looking at, but it's a paper dealing with appointments of members to the BVI Health Services Authority Board. Do you see that at the top there?
Yes, sir.
And if you go over to the next page, 3272.
Yes, sir.
We see that the decision, and it is a decision that is made by cabinet, was that 6 people, 6 potential candidates would be appointed to the board with effect from the 19th of June 2019, with 1 person being deferred. We see that at B, and that was the prospective deputy chair. Were you aware that this is in May 2019? Were you aware that shortly before that, in April 2019, the appointments of 2 of the 6 listed on that page had been revoked?
I was aware while preparing the affidavit, yes. I became aware while preparing the affidavit.
Because the circumstances you have, in April 2019, the minister revoking 2 members from the board, and removing them, and that's before their term is up, and then reappointing them later on. Can you help the Commission to understand the circumstances in which that arose? Because it's two decisions separated by weeks.
I was not intimate with that process. I suspect this may have been a part of the refer to the affidavit, and now to find that.
Is this your first affidavit, Mr. Bertie?
Page 254 is your affidavit concerning the health.
This one, 254 in this.
254 in bundle 1.
Okay. If you would pose your question again, please. I'm not certain I
Yes.
recall exactly.
Let me try and help you with it.
Sure.
And not least because you've explained that I think this was something that you became aware of during the course of
the preparation of the affidavit, yes.
If you look at 3303, which is in the same bundle.
3303.
Yeah.
Okay.
So that's a ministry memorandum headed revocation of appointments, and it's dated 30th of April 2019, then signed 7th of May 2019 by the Honourable Malone.
Yes, sir.
And that's the memorandum that deals with, which went to Cabinet and led to revocation of the board, members of the board. And two of those members were Dr. Yvonne Renee Benson and Mrs. Kishelle Blaise Cameron. So they were revoked in May 2019. If we go back then...
But just pausing there, did you have anything to do with this part of the exercise, the revocation?
No, sir.
So did you know anything about it? At the time?
No.
So you learned about this when you came to the appointments process?
To the appointments?
To the process of appointing the new board after the revocation?
Not necessarily either. At that time when this was done, I was a deputy secretary in the ministry.
Right, okay.
Having oversight for a different area of the ministry. So I was not intimate with this process.
Yes, yes.
Sorry.
So the events that we're talking of, you had no direct involvement in at all?
No.
And if memory is right, it was the 7th of June of this year that you took on the role of permanent secretary, is that right?
That's correct.
So any information that you can help the Commissioner with has come as a part of preparing the affidavits.
That is correct.
Which will have involved, as you've explained, discussing matters with your with colleagues in the ministry.
In preparing the affidavits. Yes, that's correct.
Well, hopefully, and we can try and take it shortly, and if you can't help us, just tell us. So just to orientate you, there is a decision in May 2019 to revoke people from the board.
Okay.
And when we go back to the document that we were looking at,
which is the minutes?
Yes, there is then reappointment to the board, which is at 3271. and that's 19th of June 2019. So at 3272, we see that 6 individuals are appointed to the board with a period of 2 years, or term of 2 years, and that includes the Mrs. Cashel Blaise Cameron and Dr. Yvonne Renee Venza, both of whom had been revoked in May. So in 1 month they are revoked, and in another one they are reappointed.
Okay.
Now, this will have come from discussions you may have had in the course of preparing your affidavit. But did you find out any information about how this state of affairs arose?
No.
If we deal then with the matters that were put to you as potential criticisms, and I want to, in fairness to you, Ms. Bertie, to give you an opportunity to deal with those potential criticisms as much as you want to, all right? So you have your written response with you, do you?
A written response to the affidavit, to the criticisms.
Yes.
Yes, I do.
Now, won't need to necessarily read it all out because you've accepted that the Commission can take the contents of the written response as part of the evidence. But what we've seen with the dates just a moment ago was that you had a situation where membership of the boards was revoked and then new appointments were made. And you've obviously looked at this over in the course of preparing your affidavit. The criticisms are not directed as you, Tasha, Bertie, they're directed at the permanent secretary.
That's correct.
We should make that clear to you.
I understand.
But it's this, that when one looks at this and the process that was gone through to appoint the individuals that we've just looked at, the first point was that no competency profile was compiled. And that's right, isn't it? You don't have a written document that says these are the criteria and the competencies that we need members to have.
With the exception of what is stipulated in the Act, there's no written profile outlining that information.
And it's right that none of the posts were advertised.
That is correct.
And the consideration of candidates is entirely internal, isn't it?
That is a fair assumption, yes.
What you don't have is any sort of independent process by which you identify and select candidates.
That is a fair assumption.
And because it's internal, it's not a transparent process, is it?
That becomes relative based on an individual's interpretation.
Well, transparent, and just to make it clear for you, what it is a process where it's carried out within the ministry. The details are not recorded because it's an informal discussion that goes on within the ministry, and members of the public don't know what's going on.
By that definition, yes.
And no candidate of the 6 in this process that you've been looking at, none of them were interviewed at all, were they?
Not as far as I am aware.
What's also raised as a criticism is that no due diligence was carried out in respect of these appointees.
I see that as being relative, determining what you term as due diligence and the ministry. There is a process that we're guided by, or the ministry is guided by, in relation to the Act and how that is stipulated. And I would say that the process is followed based on the information provided and guided by in the Act.
I don't want to go over ground that we've already discussed, but I do want you to have fair opportunity to tell the Commissioner as much as you think is important.
Okay.
Now, if I try and summarise it and add or tell me if I'm wrong, but it's that firstly, from your perspective, the Act is where the guidance is to be found.
Yes.
The process that you've described, the internal process that you described, is one that involves discussion between various people. Is that right?
That is correct.
Now, in terms of using that process about as the due diligence that the ministry does, is there anything else you want to add about that process that you haven't already said to the minister?
I would add, I don't think any reference has been made to the fact of the persons providing their CVs, which again would provide some guidance and some information as to their background and their interactions or their expertise that they would bring to the particular role. So I would estimate that that is a form of due diligence in relation to persons being proposed for candidacy to these boards. Again, due diligence being relative based on your interpretation as well as mine.
Well, due diligence is a heading.
Right.
And underneath is what steps did you take? And
that is a part of the due diligence process.
What I'm inviting you to tell the Commissioner is there any other steps that you took or the ministry took in relation to these candidates that were appointed in 2019 that he should know about?
I'm sorry, just to pause. As Mr. Wright says, due diligence can be seen as a heading under which steps that have been taken are listed. And I think under the due diligence head, you have listed, firstly, the requirements of the Act, whatever they are. You say that they have been complied with.
That's correct.
Secondly, that CVs were obtained and considered before the paper goes to Cabinet.
That's correct.
Anything else?
That is it.
Right. Thank you very much.
We've looked at the Cabinet paper. We've been looking at the Cabinet paper, which deals with appointments. Another potential. Do you want to go back to that, or
no? You would directly.
No, I'm sorry. My voice dropped. I was introducing my question by saying that we've already looked at this. And a point that arises from it, which I want you to have an opportunity to answer, is that no mention was made in the paper that went from your ministry to Cabinet, or in the minute of Cabinet, to the fact that, as we've said, two prospective appointees, two people who were up for appointment, had their appointments revoked less than a month before.
So the paper does not speak to.
It makes the paper makes no mention of the fact that. So you have essentially two papers and two events. You have the revocation, which involves two people, and then you have the reappointment, and they're separated by less than a month. And those two people were reappointed. And when
they were reappointed.
Yes.
Okay.
Now, when that matter went back in Cabinet for the appointment, when appointments were put before Cabinet, the memo that went to Cabinet from the ministry did not mention the fact that two of the people being put forward for appointment had their appointments previously revoked, nor did the Cabinet minute make any mention of it.
I would have to familiarize myself with the papers. I am not. I wasn't aware of that area in that.
Well, if
you're saying that is what's evidenced in the paper, I can't confirm because I've not read it. But
if you look at your written response, please.
Certainly.
If you look at point 7 on the first page, just remind yourself of that.
Point 7 of
your written response.
No. I think it's point 7 of the criticism.
Yeah, the criticisms are set out first, and then underneath in bold is Ms. Bertie's written response. And you're right, Commissioner, it's criticism 7.
Okay.
And unless there's any objection, I can read out that criticism if it will assist Ms.
Yes.
Bertie. No mention was made in the relevant cabinet paper or minutes of the fact that Dr. Venson and Mrs. Blaise Cameron's appointments were revoked less than a month earlier.
Okay.
That was the criticism. I accept you filed a written response, but is there anything else you want to say in relation to that criticism?
I mean, I think in fairness to Miss Bertie, unless there's any objection to this being read out, the paragraph at the bottom of that page, which is Miss Bertie's response, the one beginning the reappointment of, could probably be read out because that's her response to.
I can read it if you'd like me to.
Yes, I mean, there's no problem with you reading that out as far as I can see.
Okay.
Yes.
So the reappointment of and Dr. Yvonne Renee Venson and Mrs. Kishel Blaise members was consistent with achieving a balance of expertise in the new board. Will I continue?
Yes, please.
The cabinet paper specifically mentioned that each of them had served on the HSA board until 16th May 2019. No confusion or misapprehension was likely to be caused by the fact that the cabinet paper did not specifically mention that those appointments had been revoked.
So that, I mean, that's your answer really to paragraph 7.
Yes,
have you anything to add to that?
No, sir.
Thank you very much.
If you could just help us though in that context, just with this, please. If you go to 3303 in that bundle.
Yes, sir.
And 3304, so that's a memorandum from the ministry concerning revocation of appointments. If you go to the next page and look at paragraph 4, it then lists the present board at the time. Paragraph 5 says 3 of the aforementioned members. I'm sorry, I'm going to pause for a moment because in listing the current membership, it then continues at paragraph 4 that 3 vacancies were created upon the expiration of the appointments of Mrs. Ayana Liberd, who was the chairman, Mr. Kenneth Hodge, the deputy chairman, and Mr. Wellington Romney, leader of the opposition's nominee on the 19th of March 2019. And then it continues, 3 of the aforementioned members, Dr. Venson, Mrs. Blaise Cameron, and Mr. Romeo Fret, were appointed to the board in January 2019 by the then Minister for Health and Social Development, now the Leader of the Opposition. At present, the Leader of the Opposition is entitled to appoint 2 persons to serve on the board. As such, in an effort to conform with section 5.3 of the Act, revocation of these appointments is necessary to allow for the balance envisaged by the Act. Now, the reason I draw your attention to that, because it appears to link with the part of your written response that you've just read out. So could you just explain, I appreciate that you didn't draft this and you weren't permanent secretary at the time, but just explain what that paragraph 5 actually means.
From my understanding, I believe this would have been at around a period when there was a transition within government. So the Minister of Health at the time would have put forward his recommendations.
I'm sorry, by at the time, do you mean in January 2019?
That's
when
January. So the Minister of Health in January of 2019 was not the Minister of Health in
whenever it was later on in the
later
year,
on
because
in the
it was
year.
a change of administration.
Exactly, right.
So the Minister of Health in 2019, you were saying put forward these appointments.
Right. So these the 3 mentioned, Dr.
Venson, Mrs. Blaise Cameron,
Right.
and Mr. Fret.
Were appointed to the board in January of 2019, as it's stating here,
Yes.
by the then Minister of Health,
Yes.
who had now become the Leader of the Opposition.
Yes.
So I suppose in an attempt to ensure that that balance was still maintained, the reconstitution in essence was done to create that balance.
A balance of what? What's being balanced?
So the persons who would have been nominated by the leader of the opposition would not necessarily be the same as the persons who were nominated by the Minister of Health.
Yes, the individuals nominated by the Minister of Health under the previous administration,
right,
might not be the same. So it's a balance of what, a sort of political balance.
Well, I wouldn't say political balance. It's
Yes.
based on the nominations of the persons at the time.
Right.
So in essence, the persons nominated by the Minister of Health in January of 2019, not necessarily be the persons who would have been nominated by the Minister of Health in May or April of 2019.
Yes. Okay, thank you.
See you holding your head.
So is the balance, as you understand it, between how many nominations can come from the current minister as opposed to how many can come from the leader of the opposition?
That's, I believe, where the balance lies. Yes. So based on I think the Act speaks to
the Act, and we can look at it if necessary. The Act requires 2 members to be nominated by the leader of the opposition.
Yes, nominated but not appointed.
Correct.
And 2 by the leader of the opposition.
Yes.
The chairman by the minister in consultation
Correct.
with the leader of the opposition.
Yes, that's correct.
So, I mean, the minister makes all of the recommendations, but 2 of those can come from the leader of the opposition.
That's correct.
When we get to the chairman, there has to be consultation with the minister
leader and the leader of the opposition.
And then it goes to the House of Assembly in any event.
Yes.
And so if you leaving aside the chairman, I mean, in effect, it means that however big or small the committee is, and it has to be a minimum of 7, there will be 2 people on there who have been nominated by the leader of the opposition.
That's correct.
And so was your understanding of this decision, and this is obviously from discussions and researches you've made for the purpose of preparing your affidavit, was that it was to reduce the numbers that have been put forward by the previous minister, who is now the leader of the opposition?
I wouldn't say to reduce. I would say to ensure that it was in keeping with the stipulations of the Act.
Which are that no more than 2 people on the board can be nominated by the leader of the opposition.
That's correct.
I want to, again, just let's go back to your written response and just offer you fair opportunity to respond to everything. The last one, which is number 8, and is a sort of compendious potential criticism, is that following from the various matters that I've put to you, is that no reasonable effort was made to identify and select the most suitable and qualified candidates for membership of the Health Services Authority Board. Is that something that you accept, or is there anything you want to say?
I don't see it as a fair assumption and a fair assertion either. Reasonable effort, again, becomes relative based on how an individual would determine that. Because the efforts were not necessarily done on account of the assertions put forward before, does not mean that there was not reasonable effort.
And is that the particular part of the criticism that you would take issue with, that there wasn't reasonable effort?
Yes.
And that's reasonable effort by public officers within the ministry?
That's correct.
You've explained, and we've asked you about the internal process that goes on. Can I just ask you a couple of questions about the response itself, please, Ms. Bertie?
Response to question 8.
Yeah, it follows down underneath. It's a response to all of the matters, but it's just that what you say is officials research, considered and discussed with the minister the known credentials of possible appointees in the light of the functions they were to exercise. Now, you've explained that the CVs come later on in the process.
Sorry, where are you reading from exactly?
I'm looking at your response.
Second paragraph?
Second paragraph, which you've got. And then if you can see, I think 7 or 8 lines up.
Yes.
Do you have it?
Yes, I'm with you now.
Now, you've explained the process, nominations, checked for consent, and then asked for CVs. So how did officials research the known credentials of possible appointees?
The CVs would outline that information.
But the CVs don't come at that stage.
So the question is?
Well, the process as you've explained it is, nominations are made.
Well, recommendations are made.
Right.
Yes.
I switched to nominations because that was your word.
Okay.
So we'll call
any of them could be utilized.
Right. But a desk officer, permanent secretary, or the minister can come up with nominations.
Yes.
That creates the pool of candidates. What then happens is that you will contact candidates, ask if they consent to serve.
Yes.
And then get CVs.
Yes.
So my question is directed to that first part.
Okay.
You haven't yet got the CVs. So what researches do you make to identify the known credentials of possible appointees?
I would add the element of considerations based on the nominees put forward. The individuals may very well discuss or have an understanding as to a basic background on these individuals that are being considered. For example, are they fit and proper individuals of the community, good upstanding citizens? Those are things that are considered in that light.
But how do people come up with names?
How do you
come up with names? I mean, just imagine you're in a room with Carvin Malone and he says, oh, I want some names for nominations for the board.
Well, within the Ministry of Health, what we've done is look at, for example, individuals who may have retired from the public service, having had senior roles within government. Those sort of individuals may be considered or may be put forward for consideration. We've also, again, looked at individuals who have necessarily been active in the community, whether doing community service or being involved in key agencies or Rotary clubs, different organizations under the ambit of community service within the territory.
The second criticism that was made was that no conflict checks were carried out.
No
conflict checks were carried out. So that's at the last page of your written response. You'll see that it's set out there. Now, what checks are made of candidates to identify any potential conflict?
What checks are made?
Yes, so you've got a potential pool of candidates.
Yes.
That reduces when you get CVs, possibly. It's at the stage before it goes to cabinet. At that stage, do you make any check, or is there any informal part of the discussion where you discuss conflicts of interest?
Possibly more informally.
What factors would you have in mind in trying to identify a potential conflict of interest?
I really can't confirm what that would be. What?
Do you want me to, let me try and help you with this way. Go to 3271.
3271.
Yes, please.
Oh, goodness.
Now that's taking us back to the cabinet minute, and it's back to the minute that dealt with the appointments. And as you'll see, paragraph 59, there's a reference to Mr. Lemuel Smith being currently employed as the manager of Caribbean Basin Enterprises, stroke CBE Engineering, a private company owned by the Minister for Health and Social Development. And what it concludes is Cabinet was content to proceed with the paper and the recommendation. Now that's at the end of the process, when Cabinet is dealing with a potential conflict that arises. You're obviously more involved at the beginning of the process as permanent secretary, but when you are, when you're trying to find candidates, how do you identify potential conflicts of interest?
Again, that in my estimation would be very relative, based on our knowledge and more so the knowledge of the officers concerned with the matter.
But do the officers have any guidance given to them?
No.
Do they are they given any advice about what to look out for as a potential conflict of interest?
No.
In relation to these appointments, from the work that you did preparing the affidavit, did you come across any record of the stage that you would have been involved in, or the ministry officials who were involved of the discussions being about a conflict of interest?
Not to my knowledge, no, I haven't.
What was also said was that the procedures set out at paragraph 6.8 of the Cabinet Handbook were not followed. And you've responded, there's no basis for the assertion that the steps contemplated by paragraph 6.8 of the Cabinet Handbook were ignored. Candidates are asked at the time that they're approached to ascertain their willingness to serve, and officials are mindful of the need to avoid such conflicts when considering the suitability of a candidate. The Cabinet Memorandum sets out the information required by the handbook, and the considerations 6.8 mandates were part of the informal process of discussion and decision-making that led to the proposals to the Cabinet. Now, firstly, going back to the point I just canvassed with you, you say officials are mindful of the need to avoid such conflicts when considering the suitability of a candidate. Given there's no guidance, no advice, you couldn't, to your knowledge, there was no discussion in relation to the points that we're considering. What's the basis for saying that officials are mindful of the need to avoid such conflicts when considering the suitability of a candidate?
Again, I would base this on an individual's knowledge of the persons being considered, or any issues that may result on account of them being a part of the board under consideration. So in essence, if I were to use an example, there may be an instance where an individual may very well have had, I want to use this example of using the committee, for example, the Public Assistance Committee. Persons being considered for that, given an individual's intimate involvement with the, I suppose, having knowledge of the department's functioning and so forth. That might seem as a positive element that can support the work of the committee. So someone else might view it as a conflict on account that this individual may have too much information or too much working knowledge. Again, it could be looked at in a different light on the other spectrum, in that they have experience and information that would be useful to that process. If I'm
I understand that's an assessment that has to be made by somebody.
Exactly.
On information, that there's this sort of link. But where does the information about the link come from, other than
personal knowledge?
So it's just up to the officer, the person who's looking at the application or the nomination, having knowledge of that link.
That's basically where it is.
And putting it into context, I mean, the criticism is, or the potential criticism is made in relation to the 2019 appointments. Given what you've said about that, you're not in a position, are you, to say that the officials involved in that process in 2019 were mindful of the need to avoid such conflicts when considering the suitability of a candidate?
That could be a fair assumption. And again, it could very well be something that they may not have been aware of.
Because there are no records.
There's no record, there's no stipulated guideline that provides how that should be done. Is it based on what we call, I forget the term, where you ask for background check? How would that be detailed, or how would that be required in these processes?
I mean, that's as it were a question. That no background checks are done at the moment.
As far as I'm aware, no.
No, thank you.
So if that is something that we could say should be a part of the due diligence process, as we've outlined, again, it would be certainly something that could be considered and put as a part of our process to put forward nominations for consideration.
You also refer to and address paragraph 6.8 of the Cabinet Handbook in your written response. Are there any particular aspects of that paragraph, or section rather, that you want to draw the Commissioner's attention to?
I would have to look for that section to see if there's anything in particular.
Yes, where can we find the section, paragraph?
The paragraph 2786, I hope in the same bundle.
2786.
It is the right page, Ms. Bertie.
It starts on 2785.
And this stipulates how appointments should be made by the cabinet members.
Yes, it's
So this guides the cabinet members.
Yes,
in
it's
that
headed
process.
procedures for recommending appointments.
Okay.
The potential criticism that was put to you as permanent secretary is that the procedures set out of paragraph 6.8 of the handbook were not followed, and you've responded saying that no basis for the assertion that steps contemplated with paragraph 6.8 of Cabinet Handbook were ignored. My question was directed whether there was any particular part of 6.8 that your response was directed to.
I have no additional points to make in relation to that.
Can you elaborate further, though, on your response as to
From my understanding, the 6.8, the section noted in 6.8 speaks to Cabinet's arrangement in the appointment of persons to boards and committees. So I believe, as it's stated, it speaks to how they would manage that process. Cabinet meaning the members of Cabinet.
I may have misunderstood the response, because it's obviously a response directed to the permanent secretary of the ministry. And you seem to be saying there that the considerations that 6.8 mandates, and you do say, were part of the informal process of discussion and decision-making that led to the proposals of the cabinet. And so you seem to be saying that the points that are made in 6.8 were points that the ministry had in mind before the matter went to cabinet. And I just wondered whether there are any specific points, specific considerations in 6.8 you wanted to draw to the Commissioner's attention.
No, sir. I don't have any further attention to draw to any of those particular points. I think they're clear.
And there are no records of any consideration of the paragraph 6.8 criteria? Or...
No, sir.
Yes, thank you.
Commissioner, may I have a few minutes?
Certainly, yes.
Commissioner, those are my questions. Can I conclude by thanking Ms. Bertie for making the time to come and give evidence today, but also for the way in which she's given that evidence?
Yes, thank you very much, Ms. Bertie.
Thank you, sir.
As Mr. Rowett said, time and the gracious, clear and helpful way that you've given your evidence. It's much appreciated.
Thank you.
Commissioner, may I just note as well that what was said to be potential criticisms of Ms. Bertie all relate to a period before she was actually the permanent secretary?
Yes, I mean, I think Mr. Rowett made that clear, that she was being asked these questions as the acting permanent secretary, but we're very well aware and sensitive to the fact that she did not become the acting permanent secretary until June of this year. Thank you. Yes.
Our next witness is due at 2 o'clock, Commissioner.
Now, we've got, it's really outstanding business from the hearing for 4 directions yesterday concerning the redactions to the elected minister's response to the governor. Can that be dealt with at 2 o'clock?
Yes, it should be.
In that case, I mean, I don't think it'll take very long, but we can certainly put the minister off until 2:15 if that helps him. Mr. Hirey, we'll deal with the outstanding matters on the redactions in respect to the elected minister's response to the governor's position statement at 2 o'clock, because we need to knock that on the head so that we can make some progress. I don't think it'll take very long, but you probably heard what I said to Mr. Rowett. If it helps the minister to come at 2:15 rather than 2 o'clock, that's absolutely fine.
Noted, thank you. We'll convey that message.
Otherwise, 2 o'clock. Thank you very much.
Thank you.
Good. Thank you, Mr. Wright. I think we're ready to resume.
Thank you, Commissioner. Before our next witness, who will be the Honourable Carvin Malone, there are just matters which you intimated before we had the lunch break that we could usefully deal with at this point in time. Before I do so, can I just introduce the representation this afternoon? We have in the hearing room Ms. Lauren Petty, forgive me, for the Attorney General elected ministers, and she appears along with Mr. Hussein Hyrie and Mr. Edward Rizzo Gill, who are both attending remotely. Mr. Rowe, who was here this morning for the other members of the House of Assembly, does not appear to be present for this afternoon's session.
And this, the particular thing we're going to deal with before the witness doesn't concern him.
It doesn't.
No.
It doesn't. If I can turn to that, you'll recall, Commissioner, that yesterday at the directions hearing that we held yesterday morning, one of the issues that was canvassed with Mr. Hyrie was the need to progress the application for redaction to the response that the elected ministers had provided to the governor's position statement. You directed that what there should be is a covering letter which identified those parts of various documents that would be redacted together with the reason for the redaction being sought. Of course, as has been said and everybody's aware, ultimately redaction is a matter for you. But what we anticipate, therefore, would be an informed redaction application. We did receive a response. It was in a form that it was not what was expected and was not the conventional way of doing these things. It's not entirely clear what the basis of redactions is, but we have been able to consider the material and taking care not to refer to matters specifically for reasons that I hope will become clear as I go through my submissions. They can be divided into three parts. Firstly, that what has been sought by the Attorney General is the redaction of various emails and telephone numbers.
Email addresses?
Yes, that's right. So yes, of course.
I reversed.
Mr. Rowe has joined us.
Yes.
My apologies.
No,
Apologies, Commissioner. I left it on throughout my lunch and break, and I was hearing you all, but could not make the connection.
Barely started, Mr. Rowe, and this particular matter doesn't concern you or your clients.
Indeed, I appreciate it.
But in terms of redaction of email addresses and telephone numbers, those are redactions that we can accept. The next category of redaction sought it causes more difficulties, and that is redaction to a cabinet document. And I'll come to an example in a moment, but the reason we don't accept it is what the IRU were asked to do was to provide a redacted version of the document with the redaction sought blanked out so they were not visible, and a shaded version which allowed the material sought to be redacted to be still visible. Yes. They have done that, but there is a difficulty in assessing the redactions being sought because the translucent version and the blanked out version do not match. A second issue is that redaction is now being sought in relation to matters which were canvassed at hearings, and secondly, which relate to points that are made in the response. You'll remember, Commissioner, that yesterday, Mr. Hyrie confirmed to you that no redaction of the response was being sought. What was being sought was redaction of the annexes, but the difficulty, of course, is that the response does not correspond to what is being sought in terms of the annexes. And to give two examples of matters that were canvassed at hearings, and I'll explain, and which are relied upon, and I'll give this more context. You'll remember that we, during private hearings, asked questions of members of the Joint Task Force in relation to easy shipping and the purchase of radar barges. Those were at that time private hearings, but the Attorney General was given time by you, Commissioner, to consider the transcript and seek any redactions that she wanted, including on the grounds of national security. The hearings transcripts were then published, and they have been on the COI's website for some considerable time. From those transcripts, it will become clear that I, on behalf of the Commission, asked questions of customs officials, of the former police commissioner, the chief of immigration, that related to the radar barges issue, and they gave answers, and we went into it in some considerable detail. But yet we find ourselves now in a position where what is being sought, and I can give these two examples because they've actually been publicly referred to, and in one case they are actually a matter of public record. But there was concern expressed, particularly by customs officers, over the use of smaller vessels, and that was used as a justification for moving into the radar barges contract. That was ventilated at the hearing. It is on the transcript. Similarly, the offer of assistance from the UK, of military assistance from the UK, was also something that was canvassed. These are matters which are relied on in the position and the response of the elected ministers, and we'll see that at paragraph 103 of that response. Yet at the same time, redaction of the underlying detail is being sought. So the left hand is not speaking to the right. The third category is in relation to what may be described as National Security Council / Joint Task Force documents. Again, that raises the same issue, in that what is being sought is redaction of material or information that has already been aired in the course of our hearings, with witnesses closer to the information than the elected ministers are. It is also materials I've indicated that the elected ministers appear to rely on in their own response. There is an ancillary issue, which it might be said is not a matter for the Commission, but does bear on the application which, in my submission, the Attorney General needs to make and needs to get on with making. And that is, it is not entirely clear, it's a point I raised yesterday, who owns this NSC material? The response has been provided on the part of the elected ministers. What is said is that the material, because it is national security material, attracts public interest immunity. That has been said in previous correspondence from the IRU. The difficulty which I highlighted yesterday is the unwillingness of the IRU to go further than that. That's a point I'll come back to. But if they are raising these issues in relation to NSC material, you, in my submission, will be assisted by clarity as to the basis on which the Attorney General now represents the NSC, because the NSC is a separate entity under the Constitution, and just like the Cabinet is, but you had an application for participant status from the Cabinet. You haven't had such from the NSC. The reason I ask who owns the material, and I hope it's not a rhetorical question, is because the NSC may have a legitimate concern as to how this material is being handled. If it is, or contains information of such sensitivity that it attracts PII, then the question may arise, why do elected ministers who are not sitting on the NSC have access to it? May also arise as to what security measures have been put in place by the lawyers representing the Attorney General, to some of whom are based in London, some of whom are based in the BVI, and not all of whom use a secure email to ensure that this material is properly being taken care of. I add at this point, and I don't want any confusion over this, that every member of the COI team is being cleared to the highest level. Now, the reason I say it has relevance is because the time has come to stop saying this is public interest immunity and to actually make an application. As I tried to explain yesterday, a party cannot just simply raise public interest immunity. As a category of exclusion, it falls to be determined. And what's needed is a proper application. What's needed now is a proper application that says, for example, the following parts of this document, redaction is being sought because it is not relevant. But if it is being sought on grounds of public interest immunity, the starting point is the concession is that it is relevant but sensitive. And what it then falls to you as Commissioner to do is to determine where the balance lies. But in order to do that, you have to have a properly set out application that sets out the categories of national security that are engaged, that is presented in such a way, and it's known as the Part A, Part B process, such that Part A can be published and circulated to other participants if necessary, and Part B contains any submissions or information that is argued cannot be made so public. That's where we are. So it comes down to this. We cannot accept the redactions that are being sought because there is no coherence to them. And if PII is being asserted, we really must stop just running around with the phrase. The time has come to make a proper application.
Yes, thank you, Mr. Rawat. Mr. Hirey, no problem over the email addresses and telephone numbers. I mean, I've obviously looked at all of this material. It seems to me that some of the email addresses have been left in. I can't see any reason for them being left in where others have been taken out. But there's certainly no problem with the redactions that you claim over email addresses and telephone numbers. So those redactions are fine. But in relation to the other two categories, the cabinet documents and the NSC and the JTF document, what do you say about those? I mean, just before you say anything, to obtain redactions, you obviously will need to make an application. But in that context, where are we?
Thank you, Commissioner. Well, I mean, firstly, on the discrepancy point that Mr. Rawat mentions, I think if there's a discrepancy between the translucent and opaque versions, then by all means, we'll be grateful just to be pointed to it, and I'm sure we can readily reconcile that. We're looking at it anyway, so that shouldn't, I don't think, take up too much time. I mean, I think in terms of the position on the cabinet paper, I mean, the approach that's been taken is to redact where there are issues of national security. That's a particular type of public interest immunity to be weighed in. Of course, what we've done is given you, Commissioner, full versions to be able to see the information, and of course relevance is for you, so as to determine if it's considered that certain passages which are currently redacted are relevant, then by all means, you know, we can take that away and have a look at it and revert to you on that. So I think...
Sorry, Mr. Hirey, to interrupt. Just to pause for a moment. You've mixed apples and oranges there. Relevance is, of course, for me. But as Mr. Rawat said, there's a difference between relevance and PII. That's the first question. At the moment, we don't know why you want these parts redacted.
Because of national security, because of PII, of which a subset is national security, as I was just explaining. So that's the reason why the redactions have been given. If, however, you consider they're relevant, then in the weighing of the public interest, you may determine that it becomes appropriate nonetheless to have them publicly disclosed. And if it could be indicated which passages in particular are considered by you to be relevant and you would wish to disclose, then it may well be that there isn't any point of divergence on the ultimate issue.
If you're relying upon PII, then you accept relevance and you're relying upon PII, which is fine in a conceptual way. But you do have to put forward a justification for why you're claiming PII over this material. It's not sufficient. I'm afraid I'm old enough to remember when it was sufficient to simply for a government to say national security. But it's not now. You have to put forward justification. And further, again, a point made by Mr. Rawat, when you say we consider this, who is within the scope of we? Are you representing the NSC?
Sorry, I thought we were talking about cabinet papers right now. I wasn't on to the third point on NSC yet.
Okay, fair enough. In terms then of the cabinet papers, you are able to put forward an application indicating precisely why you think that these parts should be redacted.
Well, I mean, if an application is considered a good use of time and proportionate in the circumstances, this was raised yesterday, and we've responded on the issue, you know, within hours. But if an application is necessary and proportionate, we will put in an application.
With respect, Mr. Hira, that's not fair. You have responded, and you responded within hours of the hearing, but you've only responded after a considerable amount of chasing from the COI team. But let's move on to the NSC material. What do you say about that?
Well, we have had correspondence on the point, and I absolutely agree there's been correspondence back and forth. The other thing I would just mention still on the cabinet issue is that it's one thing to make mention of a point, and it's another thing to publish it in its complete unredacted form. But again, as I say, we're prepared to take and those that instruct me, a constructive approach on it. So if there are any particular issues, we can certainly take that away. I'll come on to the NSC point. So I think NSC documents are, of course, highly confidential. Of course, they are highly sensitive, and they relate to issues of national security. And so that is the reason for, again, the redaction of material that is not relevant in the first instance for the Commission of Inquiry. Of course, again, you see the material in unredacted form. Nothing is being withheld from you, sir. And if you take a different view, then again, I can take instructions and the NSC can consider whether to consent to the publication of the material, which is what they have done in this context. So the NSC has approved it formally, and it's been submitted to the COI on a confidential basis, of course, relying on that framework and assurances. But the formal approval for it to be published has also been given by the NSC. And it's on that basis that you have the documents both in redacted and in unredacted form. But again, if there are specific issues where it's considered by you that redactions ought not to have been made, again, I can take instructions, and I can assure you that the approach of the NSC is not to withhold anything that's relevant to the particular points, similarly as with the approach of Cabinet.
So you are representing the NSC because they aren't a participant, you see?
No, I'm not representing the NSC, but what I can say is I'm aware of the NSC's approval, their consent to the publication of the material which has been shared. So in that sense, I'm able to convey what it is they have approved, which hopefully should be of assistance to you.
Well, I'm not sure that you've allayed my concerns, but Mr. Rao, what do you say in response to those two areas? We're not worried about the emails and the telephone numbers.
The first point to make is that it's difficult to understand the argument that relevance is not engaged here in circumstances when what we are considering is material that the elected ministers chose to put before you. This is not material that came in by other means in which the COI is wanting to use. This is material that the elected ministers positively say you need to consider. And the second point I would make is that the NSC includes the governor, and it might be important for Mr. Hirey to confirm whether or not the correspondence he has had has included the governor. I'll pause there.
Before he does, and my memory is struggling, but isn't the police commissioner also on the NSC?
Yes, again, from memory, it's the premier, the deputy premier, the attorney general, the police commissioner, both I think are non-voting, but then it's chaired by the governor.
Yes, okay.
maybe we
and this has been approved. I don't think you're wrong in terms of members of the NSE. This has been approved by the NSE. There are important sensitive issues of national security to do with, and if you wish to get into detail, perhaps it'd be more appropriate to have a private hearing, at least on this specific matter, so that I can give some illustration. I would have thought it was not beyond the realms of consideration that the NSE would be dealing with sensitive issues of national security, and that they would not wish those to be published. I would have thought that was relatively uncontroversial, but maybe I'm wrong.
Well, no, I think it is probably uncontroversial. Does that mean that within the IRU team, who have access to this document, all are security cleared? Don't answer it if you don't know.
I can answer that all of the IRU that have access to this document have given an oath and a suitable undertaking to the satisfaction of the Attorney General.
Do I take it that they have not been security cleared by that answer?
Well, my answer is with regards to the oath that they have given, with regards to confidentiality. I don't believe I could add anything further to that point.
Okay. Well, I take it that they're not security cleared.
Could I just come back on
yes,
one
Mr.
point? Where I struggle with Mr. Hyry's submissions is that his proposal doesn't fit in with the normal conventional approach to PII application. The starting point, if you're going to make a PII application, is that you're saying that the material is relevant but sensitive and therefore must be redacted. So an argument that the Commission has seen it in unredacted form is irrelevant, because if PII is upheld, it cannot be used. The second point of the process is that it is not enough to say national security. It's not enough to say public interest immunity. You have to say what interests are engaged specifically under PII. And Mr. Hyry speaks of a private hearing. We can have a private hearing, but in order to have a private hearing, we need a properly set out PII application.
Mr. Rao, if you genuinely want a constructive way forward to remove the redactions that you think need to be removed so that the minister's response can be published as soon as possible, then I suggest that the most efficient way of doing that is to set out those passages that you think ought to be published, and we can get back as soon as possible. That would avoid any delay. And I'm sure it's in the interest of all to have this published as soon as possible. So we're in a sense, tell us what you have an issue with on the specifics, and we'll be glad to take it away and come back as soon as possible, so we can remove the hurdle rather than creating one that we say we can't get around.
That's just not how it works. If you want it redacted, apply for it to be redacted.
Mr. Hyry, we have a witness waiting, and I'm anxious to get on with the evidence. But this must be dealt with, firstly, properly, and secondly, promptly. The proper way of dealing with it, as you know, is to make a formal and proper application to me for the redactions that you seek. I will then make a ruling on those redactions. What I'll direct is that application is made by 4 p.m. on Thursday, and I will hear the application at 9:30 on Monday. We simply cannot go around in circles, but the circle is broken by you making the conventional, the usual application in relation to a PII claim based on national security. It's not for me or for Mr. Rawat or for anybody else to guess at these matters. That's the way we'll proceed. Can I just, I think, correct one point that Mr. Rawat made? It's only a small point. He said the team have been security cleared to the highest level. I think I probably have, but I think he meant have been cleared to a sufficiently high level. There are, in fact, quite high levels of security clearance that are relevant. But in any event, we have all been security cleared, which gives me some comfort that you can't confirm that those who've had this document are security cleared does not give me
When you say this document, I'm referring to an expedited extract of an approval. So
I was referring to the NSC documents. Yes.
If you're referring to the NSC documents.
Good. Ms. Iris, is that okay? Is that clear?
Commissioner, if you'd like an application, then we shall make. Good.
Thank you very much.
Can I just raise one final matter whilst we have Mr. Hyrie with us? On the 3rd of September, the COI wrote to the Attorney General in relation to government leases, and the letter explained that on the 7th of June 2021, we had written requesting an affidavit from the Premier and the Minister of Finance in relation to this topic. That affidavit has not yet been received. We also wanted to have a response in relation to redactions and the use of this of the disclosure that we have received on the topic of leases at a hearing, and that your direction was that the Attorney General do so by this afternoon. So I would just welcome if Mr. Hyrie could confirm, firstly, whether we are going to be given proposed redactions on this material by 4 p.m. today, and that's the material in relation to leases. And secondly, when are we going to get the affidavit that was requested on the 7th of June 2021?
Mr. Hyrie, these requests are not made randomly. We are anxious to timetable our hearings. And you've asked us to prioritise. We have here prioritised. We just need confirmation that we can go ahead on this topic with a firm foundation.
Yes, I believe things are moving forward for Cabinet to approve waiver with regards to the leases bundle. So that is in train. I don't know about whether 4 p.m. today is going to be feasible, but I think it is in train, certainly.
Right. I mean, with respect, Mr. Hyrie, quite a lot of things are in train. And,
they are, sir. They are.
And the Cabinet do have a great deal to consider. What we want to know is, when are we going to get the affidavit, and when are we going to get the redactions?
Yes, and as I mentioned yesterday, sir, with dealing with 59 affidavits, there is a lot to consider, in addition to the very small public officials, the public service running the jurisdiction, running the territory. But having raised that affidavit in particular today, that is helpful because it'll enable me to put a laser-like focus on that specific affidavit that you've just mentioned.
Yes, the affidavit was requested on the 7th of June. But are you able to confirm that we're going to get these by 4 p.m. today? Are you able to give us any indication of when we might get them? We want to put this into the timetable, this topic into the timetable. It's difficult without any response from the government.
Yes, sir. I don't think it's no response from the government. We've responded to 3 deadlines between yesterday's hearing and today. This one is moving, I can assure you. I can't give you an exact time right now, but I can tell you that all effort is being made to expedite it in the best efforts way that is possible. We are being given, and the government is being given, multiple very tight timeframes. Some may consider, in some cases, unreasonably short timeframes. Now, we appreciate, of course, that you have a timetable that has been set and you wish to make it, and we're doing all that we can, and the government is doing all that it can to assist you in full expedition towards that time frame that you have, sir.
But you have no idea when we might get this information?
I mean, I think to say no idea is probably overstating it. I mean, I'm not sure that I can say it's going to be in by 4 p.m. today. I can undertake to revert with an indication of timing in the course of today, if that would be helpful.
Yes, please. By 4 p.m. today, because I suspect that it's not going to appear by 4 p.m. today. By 4 p.m. today, if you could please write to us, setting out precisely when the affidavit is going to arrive and when the response on redactions is going to arrive.
So that's in half an hour.
By 4 p.m. today.
I believe that's half an hour your time. Is that right? Oh no, maybe that's an hour and a half your time.
I'm sorry, Mr. Hyre. I simply don't know where you are.
I'm in London, so it's I think it's an hour and a half. Well, I'll be online with you with the hearing and others in the team as well. But we will alongside that we will manage this to get you the response.
Thank you very much. And as I say, just to put it into context, the initial request was made on the 6th of March for disclosure on this topic. The disclosure was what might be described as bad, wholly disorganised and incomplete. That is why we asked for the affidavit on the 7th of June, and it's now the 7th of September. Good, thank you, Mr. Hyre. I think we're now in a position to move on to the evidence.
Hope so, yes.
Good, thank you very much. Thank you, Mr. Hyre.
Thank you.
Commissioner, unless you direct otherwise, I wasn't going to ask the Honourable Malone the oath or affirmation. He's done it already.
We can remove. No. Please take a seat, Mr. Wear a mask or don't wear a mask as you feel more comfortable. We're socially distant.
To speak more.
Yes, and
pointedly.
Your voice would be captured better without a mask, but we're all socially distanced. Secondly, you've given evidence before, thank you. So you've been sworn, that oath still applies. We needn't swear you again.
Yes.
Mr. Rawat.
Thank you, Commissioner. Honourable Malone, thank you for returning to give further evidence to the Commission today.
Yes.
You will see that just to your left, there are a set of bundles. You don't need to open those immediately, but I may need to take you to some of the documents in there as we go through your evidence.
Thank you.
Could I ask you, as the Commissioner has done, just to remember, please, to keep your voice up. I need to remember the same thing, but you'll see that there's a microphone in front of you. It won't amplify your voice. So what we do need to do, it's important to hear you. And a lesson I've learned from this morning, the witness this morning, was that we should both try and avoid to speak over each other. So hopefully we can do that. Can I just begin by asking your view as a minister as to your role? Section 56 of the Constitution prescribes that a ministry is under the direction and control of a minister. Is that something that you agree with?
Yes.
And obviously, that direction and control extends to a permanent secretary who you will have supervising the ministry on your behalf.
That's correct.
Now, as I'm sure you'll be aware, the topic that the Commission is looking at the moment is that of statutory boards. Could you just confirm which are the bodies that come under your ministry?
Which of the boards?
Yes, which statutory boards come under your ministry?
Health Services Authority.
What about the Public Assistance Committee?
Well, I heard it being referred to today as a statutory body. It is under the ministry. I'm not, I thought Social Security and Health Services Authority were the two, but I understand that you had instructed the ministry that it is deemed to be a statutory body.
Well, I'm sorry to interrupt, Mr. Rawat. It's a body because I don't think there's anything in this.
No,
yes. But it's a body established by a statute. But I understand that you regard boards such as the health board as not exactly the same as the committee, which is a statutory committee. But they're both under your umbrella.
They are.
Yes.
Well, so too are a number of other boards, but we would. Those are in terms of statutory body, because even those who were in the ministry 40 years and 25 years, they had to revert back to the fact that was under the statutory body designation.
What we heard evidence from Ms. Tasha Bertie this morning, who is your acting permanent secretary, and she explained that the two bodies, if you like, that she'd identified as coming under the ministry are the Public Assistance Committee and the BVI Health Services Authority Board, which I'm going to refer to, if I may, just as of the board.
Yes.
Other than that, I mean, you mentioned the Social Security Board. That doesn't come under your remit.
Not anymore. It was before, and then it was it was moved to the Ministry of Natural Resources.
That was actually going to be my next question, because we're aware that when your administration came into government, there was a reorganizing of ministerial portfolios. Was that at the time that the Social Security Board moved to another ministry?
Yeah, it was moved months after, but yes, it was moved subsequently.
Ms. Bertie has helpfully provided two affidavits to the Commissioner, setting out the process by which, and this is non-government members, are recruited to either the board or the Public Assistance Committee. She explains that they were made on your behalf. You received a letter of request from the Commission. Have you been able to read those affidavits?
Of course.
Yes.
Well, yes, because once you had them approved by the particular lawyers and so forth, they came and they basically took it based on their positions in terms of in the office having prepared all of the documents. They were able to prepare the affidavits. Did you yourself have any input in the? No, I didn't. I was unable to read it or input on it. But I don't want you to be caught out or be surprised, but have you had a chance to look at those affidavits? No, because I know of what they were said, but the answers to them, no, because they were empowered to go ahead and to answer them. I see. I think where we are is that you've had an opportunity to look at them. So if you need any help sure. in relation to them, do ask, and I'll try and do so. What is clear from Ms. Bertie's evidence is that, and I'm going to summarize the process in terms of recruiting or selecting new appointees to either the board or the committee. And it's very much a summary, but it's going that within the department, within the ministry, there is an internal discussion which will involve permanent secretary, desk officer, and yourself as a minister. Yes. Names are put forward, which are, people are nominated. Once that pool of candidates is identified, at that point, someone in the ministry will go to them and say, are you willing to serve? And if so, give us your CV. That's correct. And then that ultimately leads to a paper that is then put before Cabinet, because ultimately you as Minister recommend to Cabinet and Cabinet does approval. There's some difference there because, for example, the chairman of the I think it's of the Health Board has to be approved by the House of Assembly. But broadly, that's the detail. Would you accept that? Well, yes, there are sometimes in the middle where you say that I would give to Cabinet and they approve. They will review, and then if agreed, they'll approve. Fair enough. But the point is that the end of that process before it goes Cabinet, you're at the end of that. You as the minister can decide, well, I'm not going to recommend this person to Cabinet, or I don't accept this nomination. Ultimately, it's your decision what goes in that paper and goes to Cabinet, isn't it? And so too it should. Now,
you were sent a letter notifying you of potential criticisms.
Yes.
And you helpfully provided the Commissioner with a written response to those potential criticisms.
Yes.
And it's important that I refer to them as potential criticisms,
yes.
because the reason they are being put, Honourable Malone, is because the Commissioner wants to ensure procedural fairness to you.
Yes.
And so they don't represent any concluded or provisional view of the Commissioner, as the letter explained to you.
Yes.
Can I just, because we will want to look at some of the details of your response so that we can put your evidence in proper
Sure.
context, but can you confirm that you're content that that written response formed part of the evidence before the Commissioner?
That's correct.
Thank you. Now, if you could look, please, I'm afraid we will jump around the bundles a little bit. Part 4 bundle.
Part 4.
If you go, Honourable Malone, please, to the back of the bundle to page 3962. You should, if we're both on the right page, be at the Public Assistance Act of 2013.
That's correct.
And that, as Ms. Bertie explained, is the act that underpins and creates the Public Assistance Committee.
Yes.
And it also it deals with a lot of matters in relation to the committee, but it includes the process by which members of that committee, and if I explain as we go through, when I'm referring to members, I'm going to be referring to anyone who is not an ex officio member.
Yes.
But members, how they're appointed, and indeed how they can be removed from the committee.
Good.
And if we look at 3964, please. Do you see section 3 there? Which is
Establishment of Public Assistance Committee.
If I direct you to section 3.2, that I'm going to suggest to you shows the role that the Minister plays.
Sure.
And that is that it falls to you to, with the approval of Cabinet, appoint not more than 8 other persons, if we see it B, to the committee. So these are the non-government members, and there are various categories of if you like, criteria that are required. Ms. Bertie's evidence was that when the Ministry is looking for suitable candidates for the Public Assistance Committee, this is what they will have regard to. Is that a provision that you were aware of?
Yes. As it is with the other board, with the other body, Health Services Authority.
Just to reassure you, Honourable Malone, I'll take you to that as well, just so that we can have a look at it.
But it's in similar form, you're right.
Yes.
And then what it does is also say, and this is at 3966, if you could turn that up, please, Honourable Malone. At 8, do you see there that there's a section that deals with tenure of office?
Yes.
And the first one is, it says that a member of the committee can hold office for a period not exceeding 3 years, but is eligible for reappointment.
Yes.
At 2, it says the member of the committee can resign. But then at 3, we say the Minister may, by written notice, remove a member other than an ex officio member from office if satisfied that the member has, and then it sets out 4 categories of things that the member could where the members may need to be removed. So the first one is absence. The second is bankruptcy. The third is conviction of an offence, including one of dishonesty. And the fourth is loss of mental capacity. And now Ms. Bertie's explained to the Commissioner, her understanding was that those are the categories on which a minister can remove, and there's no other power in the Act for the minister to remove.
Based on how she explained it.
Yes,
Okay.
but is that what you understand the Act to give you as power?
Well, this is the bone of interpretation, yes?
Well, I want to take it in stages, because it may be that you'll suggest in due course to the Commission that there is another power in another statute or another basis on which you can remove members.
And on that I rely, yes.
Yes, well, may I come back to that? Because I will give you a chance to explain that to the Commissioner. But just looking at this Act by itself, it does seem clear, doesn't it, that unless you can put someone into one of those four categories, you cannot remove them.
Well, based on the 3A, B, C, and D, yes, there are four distinct areas.
And what it doesn't have is an E that says, you know, a member of the committee, the minister can remove a member of the committee if he finds there's reasonable justification. Or it doesn't say the minister can remove a member of the committee at his own discretion.
Well, as I'm saying, it is an area where the particular interpretation, but there are other areas in which this will come up for discussion, and we will get to that.
Well, all right. So I think we're at the same place, though, that the Act doesn't. It is what it is. If you can get someone into those four categories, you can act. But if you can't, you have no power to do so.
Well, I wouldn't say I wouldn't have any power under this,
Under the
but there are other areas.
You mentioned the BVI board, and having told you I was going to call it the board, I've now changed the name, but the board.
Well, we call it the HSA, Health Services Authority.
I think I'd like to stick to the board, because that's how I described it to Ms. Bertie, so it makes it a little bit more straightforward. If you could go to put that bundle away, please.
Sorry, and get which bundle?
Part one. If you turn up, please, Honourable Malone, page 265.
Six. Yes.
That's the first page of the BVI Health Services Authority Act, and it's the act that in part establishes the board.
Yes.
If you turn, please, to page 269. This is the point that you made a few moments ago to the Commissioner, Honourable Malone. What's on that page is section 5.3 of the Act, which sets out that you as Minister appoint, again with the approval of the Cabinet, you can appoint no less than 7 or more than 9 members to the board. And continues that, and I won't read it out, but it points to knowledge and experience in various areas as indicative of the kind of person that you need to have serving on the board.
Sure. That's
right, isn't it? Now, before we go on, again, you've got 2 statutory bodies under the umbrella of your ministry, both operating under 2 different statutes. Have you read both of those statutes?
Well, I did read it, yes, both of them. In fact, the number, as I say, number of other legislation or body has about 25 acts under the health and social development.
But obviously, because we're interested in statutory boards,
the answer is yes.
These are the two acts that I'm going to ask you about. When did you first read them?
Well, we were elected 25th February, and the boards were coming up for actual review. I think the first set of boards were being viewed by the cabinet in March, and the HSA board came up in April. So we were looking in terms of all boards. So we had a chance to look through all of these. Sorry, under my ministry,
yes.
One with Social Security, the one with
Do you mind
HSA.
I just break that down a little? Because obviously you have, if you like, you wear more than one hat, and in this context, you are the minister, but you're also a member of cabinet.
That's correct.
So if we break your answer down a little bit, as minister, you're responsible for two bodies, Public Assistance Committee and the board.
That's correct.
And you've explained that one of those came up before cabinet in March 2019. Before that to date, between your appointment and the board beginning to come up before cabinet, when had you read these two statutes?
So between election,
yeah,
my appointment as minister,
yes,
and when it came up,
yes.
Well, it was after the appointment, because I could have been appointed to any of the other four ministries.
But once appointed, how soon after that did you read these two statutes?
So many events that came between, but it was clearly after we knew that we were looking at the Social Security Board, we were looking at the HSA, and we were looking at the other particular bodies, then they were read.
So certainly when your bodies came before cabinet, and in the case of the Public Assistance Committee, there was a
it came later, yes.
But by then you were familiar with both statutes.
Well, I read it in terms of getting familiar with it, because there is a very big ministry, but the answer is yes. It was read as it relates to appointments and the others, because there were some concerns in terms of how we move forward.
Now you spoke about cabinet, because you referred to all boards. And so as a member of cabinet, you were involved in also looking at other boards that were not under your ministry, is that right?
That's correct.
And when you were doing that, did you also take the opportunity to familiarize yourself with the statute that governed those other boards?
Well, only as it relates to the matters that came before the cabinet at the particular time, because as you would appreciate, there are a number of other boards and bodies, but the items that came before, specifically before cabinet, then we had to familiarize ourselves with the papers that were being brought before us.
If you turn up page 286, please, Honourable Malone.
286.
You've explained that, I think it was March or April, that the board came before cabinet. I think it was April, wasn't it? And there was then, I think, cabinet decisions in relation to revoking some members from the board and also appointing new members to the board. I just wanted to draw your attention to page 286, which is also part of the act that regulates the board, and it's Schedule 1. And we're looking at Section 1 of Schedule 1, which relates to tenures of office. And so it makes the point, which we've seen in other statutes, that the maximum appointment is 3 years, but someone can be appointed for less than 3, can't they?
Yes.
And then if we go over, please, to the next page, 287, and look at number 3 there. That deals with how you, and as minister, with the approval of cabinet, you can remove a member of a board if you're satisfied that, and again, I will summarize. Firstly, absence is one of them. Secondly, is that they are disqualified under Section 5.7 of the Act. And that section deals with circumstances such as somebody becoming a member of the House of Assembly, or becoming bankrupt, or being convicted, or being certified to be an unsound mind. And then the last two that you also have is that someone's unable or unfit to discharge his functions as a member of the board, or is in breach of any condition imposed upon his appointment. Now, first question is, were you familiar with the statutory basis on which you as a minister, with the approval of cabinet, could remove a member of the board?
Yes, and further advice was sought.
I think that's again something, if we could come back to that, but I will allow you an opportunity to explain that further advice that was being sought. But certainly, can we just confirm that you were familiar with these provisions before you started getting involved into decisions about the board?
Well, the answer is yes, and as I said, being familiar with it, further advice was sought.
I'm going to take you, as we go through, Honourable Malone, to the cabinet papers that deal with the board and the decisions that were made. That will be the point at which I will ask you, if I may, just to explain the context of further advice being sought. Okay. But again, it's right, isn't it, that when you look at that provision on its own, it doesn't give you, under this Act, any other power to remove a member from the board.
Well, for the fifth time again, we knew exactly what it says, 3(1), A, B, C, and D. And as a result of that, further advice was sought so that we can then get to the...
So again, I'm sorry I'm being pedantic, or Mr. Rawat's being pedantic, but you sought further advice because you were aware that paragraph 3 of this schedule did not allow the removal of a member other than for those 4 reasons. That's why you sought further advice, as I understand it. As I understand your answer.
Yeah.
Yes. Thank you very much.
If you could turn now, please, to put that bundle away, and if you could take part 3, please, Honourable Malone. Could you turn up, please, page 2928.
2928.
This is a memorandum from the Premier's office, and it's headed Revocation of Membership of Statutory Boards under the Premier's office. And I just want to draw your attention to some parts of it. If you could turn to the next page and we look at paragraph 4, please.
2929.
That's it, thank you. Seems to be, at least in that page, there's a slight double numbering of the paragraphs, but it's number 4. What's written there in this memorandum is, with each new government administration, it is common practice that some or all current board membership is dissolved and new members appointed to the respective boards. The manifesto of the new government administration calls for innovative, forward and progressive ideas, initiatives and action from each government ministry, department and agency during this recovery period. For those initiatives that must be implemented through a statutory body, the same principles for innovative, forward and progressive initiatives and action will be required. Paragraph 5 reads, the manifesto of the new government administration places heavy emphasis on youth involvement in every aspect of the development of the territory. As such, the intention is also to appoint a youth representative on each statutory board and committee. In addition, recommendations will be forthcoming for a new policy to amend the membership terms of each board to not extend beyond the terms of the sitting administration that appointed the board. The next paragraph reads, as such, Cabinet's approval is being sought to revoke the membership of the current statutory boards under the Premier's office portfolio, to allow for the right mix of new, innovative and progressive-minded members to be appointed that would include representations of youths on each board. And then if we take you through just to 9, please. And that reads under the heading Financial Implications. I have noted the comments of the Attorney General when he stated, quote, I have not had the opportunity to review the removal provisions of all the boards, open bracket, statutory corporation or otherwise, close brackets, end quote. To this end, it is critically important that Cabinet satisfies itself that even in the cases of the BVI Ports Authority and BVI Electricity Boards, wherein there is express provision for the removal of statutory board members, and as cautioned by the Attorney General, the discretionary powers of Cabinet must be exercised reasonably. In light of the above, before Cabinet takes the decision to remove any board director of a statutory board, Cabinet must satisfy itself that it not only has the power to do so, as per the respective statutes establishing the boards, but that in removing the directors en masse, that this will not easily be construed by any arbiter as acting, behaving unreasonably. To act otherwise in these circumstances may expose governments to claims of unreasonable dismissals, which in turn could result in huge financial liabilities being attached to government. I'm going to stop there, Honourable Malone, because I just wanted to draw your attention to the generality of this memorandum. I appreciate that it relates to boards that fall under the Premier's umbrella, if you like, and not the boards that specifically fall to you. But can I take you now, it's, I hope, in the same bundle, to 2737.
2737.
You should have there, Honourable Malone, the first page of the Cabinet minutes of a meeting on 27th of March 2019. It's meeting number 2 of 2019. Do you have that?
I see Cabinet meeting number 2, 2019. That's the heading on top?
Yes.
Okay, fine.
Thank you. If you turn through now, please, to page 2739. We'll see there where the memorandum of that we have just been looking at was discussed by Cabinet. And again, apologise, Commissioner, it might take a little time, but I think it's important if we just read some of the detail of this, this part of the minute into the record. And
this is with the board, HSA board?
No, again, do you remember the memo that I showed you just a few moments ago? I can take you back to it.
No, fine. I remember.
Yeah.
Just to clarify, the memo was just about the boards under the Premier's umbrella.
Right.
And this is the deliberations of that paper.
I know, but I would think that the Premier will come to go through this particular part, except that you're saying that it has specific relevance to the board, HSA.
Correct.
And,
okay,
and it also has relevance to you as a Cabinet member, and your reference earlier to the role, the fact that you were reviewing all boards. And so before we get into that detail, and indeed the detail about the board or the HSA, it's important to give it some context. Under the heading deliberations, it begins, and this is at paragraph 3, the Premier presented this paper. The chairman stated that specific reasons or a reasonable justification should be given to remove persons as members of a board. He asked if there was sufficient reason in this regard. The Attorney General confirmed that the BVI Tourist Board Ordinance does not reference removal of members from the board. Therefore, in this instance, removal of members can be carried out on the basis of discretion. The chairman reiterated that there is no specific removal power in the ordinance, but that he understands from the Attorney General that such a clause is included in the Interpretation Act. The AG said in cases where any powers are conferred by the legislature, One should provide reasons for removal of persons and suggested that it is better to provide reasons. The AG advised that if this administration wants to be a government consistent with public administration, then reasons must be given for removal of members of boards. Members asked if there were any precedent of unreasonable exercise. The Minister for HSD, that's Health and Social Development, commented that given its national mandate and that tourism is an economic pillar, it should be deemed reasonable that the tourism minister be comfortable with the membership of the BVI Tourist Board to move the sector forward, and therefore should be mindful to appoint a board that reflects his administration's mandate. I'm going to pause there, Honourable Malone, because that's a contribution by you. You seem to be saying, and please correct me if I'm reading this wrong, that, and this obviously the debate is in relation to the BVI Tourist Board, and that the ordinance for that tourist board is different from the acts that you had as ministers, because it didn't give specific basis on which you can remove someone. And the point you seem to be making here is that if a minister has to be comfortable with the board, and if the minister isn't comfortable with the board, and the board doesn't reflect the minister's mandate or the administration's mandate, then that was a perfectly good reason to remove the board. Was that your view?
Well, it goes in context in terms of the administration, because we ran a particular campaign on making sure that we were able to deliver to the people of the Virgin Islands. And whether it's going to be stature or otherwise, we were going to be able to have an inclusive body that would have the youth, as we actually spoke about earlier. We were also not listed here, but we were going to have someone representing the sister islands. Number two, we were going to have a number of other criteria based on the act in terms of how you appoint them, but you want to make sure that there were areas covered within the reconstruct of the boards to reflect, so we can get it out. So it is one in which it is not only for good feeling of the minister, but in terms of making sure the mandate that was promised to the people could be carried out.
You don't, in that intervention at paragraph 9, mention either youths or sister islands.
Well, it's a...
What you seem to be saying is that if the minister decides that the board isn't in accord with the administration's mandate, then the minister is perfectly justified in removing the board.
As I'm saying, it's not just a good feeling. It is one in which that was taken in a broader context of what we had. You read earlier what the particular from the minutes 103 of 2019, the manifesto of the new government administration calls for innovative, forward, and progressive particular ideas, and this was in concert with that.
So your comment should be read in the context of that part of Memorandum 103 of 2019.
Yes.
Let's read on, because the minute continues, and this is at paragraph 10. The chairman.
And may I?
Certainly, yes.
But what you would appreciate is that this was a total sum of 1 or 2 months being first elected to office. So we were basically being looking at the manifesto, looking at what the government agenda was and how best we can have this forward. So they might well, after 31 months now, 31 months, we can then have a better appreciation even for other areas that might need to be adjusted so that we can then get this done.
May I come back to that point when we look at the decisions that were made in relation to your board as well, please?
Exactly.
Let's continue with the next part of this minute. The chairman stated that there should be an avoidance of risk of targeting people. He voiced his concern about the captioned paper, and that's a reference to the memo, and that he was sure that he was not against its intention, but he wanted to ensure that there was a demonstration of good governance procedure. The chairman reiterated that justifiable reasons should be given to remove members from a board. The next paragraph reads, the Minister for Natural Resources, Labour and Immigration mentioned that the decision was not for the removal of one person, but the entire board membership. The Minister for Health and Social Development asked the AG if board members had a legal recourse for being removed. The AG responded that anyone can go to court whether they have legal recourse or not. The chairman asked if there was any operational liabilities or risk to revoking the appointments of the members of the BVI Tourist Board or BVI Ports Authority. The Premier responded that there were no risks to either entity if they operated without a board at this time. The Premier stated that his decision to revoke the membership of the boards is on the basis that a new government has assumed office with a new mandate, and as a result, he has decided to reassess the membership of all boards in a manner that will allow the mandate given by the people to be expedited in a transparent and accountable manner. Furthermore, the Premier stated that he would be recommending a policy that the membership on boards would extend for the duration of the administration's term in office. The next part of the minute is headed Action By, and that continues. The Premier would instruct his office to prepare a cabinet paper that the periods of appointments of members serving on boards would be commensurate with the administration's term in office in consultation with the Attorney General's chambers. In support, the Minister for Education, Culture, Agriculture, Fisheries, Sports and Youth Affairs agrees that boards should not exceed the tenure of an administration because it can prove to be challenging. The Minister said, I'm going to read that again. The Minister said that despite the possibility of exposing the government to certain levels of risk, when he weighs the potential for boards to interfere with the government's mandate, as a member of the cabinet, he was willing to be exposed to that risk. He stated that commitment to the government's mandate from the people must be paramount because incorrect actions of the past and/or an association with a former party or administration could have a real impact on how matters progress. The Minister for Communications and Works voiced his agreement in support of the sentiments expressed with respect to the revocation of the membership of the Caption Board. Voicing his concerns, the chairman said that the Cabinet has wide discretionary powers, which should be used in accordance with principles of administration and not without justifiable reasons. This, he said, risks undermining the Cabinet's commitment to good administration and good governance. The Premier thanked the chairman for noting his concern on the matter, but pointed out that the chairman's definition of justifiable reasons differed from theirs. The last part of this part of the minute, which I will summarise, is headed the decision sought, and it records that Cabinet approved the revocation of the appointments of all members except the ex officio members of the following boards with immediate effect, and that's the BVI Tourist Board and the BVI Ports Authority. And it then decided on an expedited extract being issued so that it could be acted upon. Now, that's, you made the point that the two documents that we've looked at arose at a very early stage of your administration's tenure in office. But it's important to ask you to look at these, because what I want you just to outline, please, is just, you've spoken about mandates and you've spoken about being innovative. What was, when you came into office, what was your administration or the administration that you are part of? What was the policy in relation to statutory boards?
Well, it was one in which, as we said again, and I think it was outlined in the earlier minutes, or in the earlier cabinet paper that you had, the manifesto of the new government administration calls for innovative, forward and progressive ideas, innovatives, and action from each government ministry, department, or agency during the recovery period. For those initiatives that must be implemented through a statutory body, the same principle of innovation, forward and progressive initiatives and action will be required. And the manifesto for the new government administration placed heavily emphasis on youth involvement. So that those same recanting of the particular paragraphs that you read earlier, and also in terms of making sure that we had.
But it isn't, can we simplify that a little bit more, particularly when we look at the decision that was made at this cabinet meeting? The policy of the government of which you are part of is to replace the membership of statutory boards, isn't it?
Well, it's to reconstruct. I wouldn't, because in my board, you would see that some of the members were reappointed. So it was a reconstruction to make sure that it fell in line with the particular act and what was intended by the act.
So when you said reappointed, their appointments were revoked, but then
Yes.
they were reappointed in the appointments process.
Yeah, because they were each considered together with any other new considerations.
Did you share the concern of the Minister for Education, Culture, Agriculture, Fisheries, Sports and Youth Affairs when he said that commitment to the current government's mandate from the people must be paramount because incorrect actions of the past and or an association with the former party? Or
Are you reading from paragraph 19?
Yes, could have a real impact on how matters progressed.
Okay, sorry. Repeat that reading.
Right. We'll both get a telling off from the stenographer if we talk over each other, Honourable Malone. But
Okay, sorry. So I don't talk over you.
and I won't talk over you either. So
Okay.
if we look at paragraph 19, I've read it out twice, so I'll try and summarise it this time. But the Minister for Education, I'll shorten his title, explained that he was prepared to take the risk of government being exposed to certain levels of risk when he weighs that against the potential for boards to interfere with the government's mandate. Did you do you agree with that? And are you prepared also to take that risk?
Well, my views are stated, so I'm sure that you'll call the minister and have him explain exactly what all there were.
I'm sorry, could you just clarify that answer?
No, what I'm saying is that there's not a yes or no to that particular question. What I'm saying is that my views were clearly expressed here in the note, and I'm going to express them to you as we move. So I'm not going to, I wouldn't be able to.
Do you have a, did you or have you, and do you have a concern that if you don't reconstruct boards, they can interfere with the government's mandate?
No, in terms of the reconstruction or the reapplication of the board, they were done consistent. In my view, they were done consistent with with the two paragraphs in 103, paragraphs 4 and paragraph 5, and there was some additional one to make sure that we had also the sister island coordination of the persons involved in that.
Did you have a concern, as the Minister for Education did, that association of board members with a former party or administration could have a real impact on how matters progress?
As I'm saying, in the context of the reorganization of the boards, I'm not sure if it was a matter of risks. We were looking in terms of fulfilling the mandate given. And in so doing, there were, as you will see in the case of the Health Services Authority, we were able to have some reappointments of bodies and the particular stuff. So I'm not characterizing risk or risk taken. I take different risks. I'm not sure if this could be categorized in terms of risking that which I myself would call myself to actually going into Section 19. The Minister for Education will come and he would actually support his argument.
But just to repeat the question, were you concerned that an association of a current board member with a former party or administration could have a real impact on how matters progress?
Well, it is a reality that there are members who have been chosen, could have that particular occurrence. But I was more concerned in terms of having a reorganization of the board to fit our particular concept of moving the government's mandate and so forth. So there were specific criteria to be done. And it was not a narrow view that I held that the mandate could not be taken out, but we wanted to make sure that we had the youth involved. We wanted to make sure that the sister island persons were involved and persons who basically could have been reviewed in the larger context of the particular act as to exactly what, how they were chosen, because each of these acts have a number of persons to be chosen by the leader of the opposition. Each of them have specific professions that they might have, and there are other boards and bodies that are specific, who are lawyers, who are medical persons, who are different actually professions. So they have a wide scope.
But given your reliance on the Premier's memo, is a fair characterization of your position that you were concerned to ensure that the boards that you were responsible for as a minister, and also the boards that were under the government of which you were a cabinet member, were in line with the government's mandate and did not seek to frustrate it?
Well, that's a reasonable thought, I would say.
I told you we would get onto the board, and let's get onto it now, please. If you could turn up page 3303, Honourable Malone.
33.
It should be in the same bundle that we've been looking at. What I'm going to do, if I explain, Honourable Malone, I'm going to take you through a number of documents just so that we have an understanding, and you have an understanding of the chronology of events in relation to the board. So what we see here is a memorandum from your ministry. The very last page is at 3308, and it carries your name and the date, the 7th of May. And if we go back to 3303, it sets out in the background information the role of the board. And then at 3, it gives you section 5.3 of the acts that we've been looking at, which summarizes the membership and the categories of people from whom members ought to be drawn. And what, if we look at 4 on 3304, we see there that the memorandum records, in addition to its ex officio members, the present board is comprised of Professor Joseph Frederick, Miss Marlene Alva McCall, Mrs. Helen Frett, Dr. Yvonne Renee Venzen, Mrs. Kishelle Blaise Cameron, and Mr. Romeo Frett. It explains that 3 vacancies were created because there had been the expiration of appointments of 3 people. So at that time, the board was only 6 people. And the statute, as we can see, mandates that it must be at least 7. It goes on at 5, though, to say 3 of the aforementioned members, Dr. Yvonne Renee Venzen, Mrs. Kishelle Blaise Cameron, and Mr. Romeo Frett, were appointed to the board in January 2019 by the then Minister for Health and Social Development, now the Leader of the Opposition. At present, the Leader of the Opposition is entitled to appoint 2 persons to serve on the board. As such, in an effort to conform with section 5.3 of the Act, revocation of these appointments is necessary to allow for the balance envisaged by the Act. Could you assist the Commissioner, please, with just explaining the last part in particular of that paragraph, that revocation of appointments was necessary to allow for the balance envisaged by the Act?
Yeah, to get to the last part, we have to get to the first part. Elections were held in February of 2019. The Minister for Health made these 3 appointments, knowing that 30 days later elections will be held. And he was also, as Leader of the Opposition, entitled to get another 2 as Leader of the Opposition. It would not have given the same construct, in my mind, in terms of a balanced view, in terms of that envisaged by the Act, number 1, and would not be consistent with what we spoke about, making sure that there were a specific construct of the board.
A political construct?
Not at all.
I don't understand the observation then.
Well, the observation is that we wanted to make sure that we had a youth, we had a Sister Island coordinator, we had 2 members that were going to be selected by the opposition, and we had the other members selected by the minister. In that the leader of the opposition, the Minister of Health in January of 2019 were all the same person.
No, I understand that the Minister of Health in the last administration was the leader of the opposition by April 2019. I understand that.
Yeah.
So what?
So, no, there would have been 5 persons in the particular view that would have been selected.
By whom?
The same person being the Minister of Health in January, and the leader of the opposition in May or April of 2019.
I understand that, Minister, but they were chosen by the Minister of Health in January.
Yes, and who happened to have been the Minister of Health and the leader of the opposition?
Well, he happened to be the leader.
All in one and one in all.
Well, not at the same time. He was the Minister of Health in January 2019 when he made the appointments.
Yes.
So that's fine. He wasn't the leader of the opposition then. When it came,
knowing that elections were coming in 30 days.
Okay, but as I say, and I don't say this pejoratively, but that's what the Act says. So I don't understand the point at the moment. I don't understand the point. If you could explain it.
Well, I'm trying to. I'm saying that it would have been a board in which there were basically we had earlier, by the same readings that Mr. Robert had said we were going to look at all the boards to make sure that they fit all the criteria in terms of getting the innovations, in terms of doing it in a matter that were consistent with what the ministry were doing, because we couldn't come and change up what the ministry itself, how they had looked in terms of board members. So it was fitting that the permanent secretary or the acting permanent secretary explained and expressed exactly how the members for the board were looked at and how they were chosen.
I mean, it's your concern, isn't it, Honourable Malone? Your concern is you come into office. If you look at paragraph 4, you come into office and you inherit a board which has, well, in fact, it's got 8 members, hasn't it? So when you come in February 2019, 9 people are still on the board, aren't they? Because Mr. Hodge, Ms. Ayana Libbard, and Mr. Wellington Romney, who is recorded as the leader of the opposition's nominee, were still in post. Their time on the board did not expire until the 19th of March. That's right, isn't it?
Yes.
So you inherit a board that has a full complement. By the time you start getting ready to take this back to cabinet, you've lost 3 people through the expiration of their terms. So your board is now down to 6, isn't it?
Yes.
And you will have to make appointments as minister to bring it up. You'd have to at least make 1 appointment, wouldn't you? Because you need 7 members under the Act.
That's correct.
But your concern is that the three of the people still on the board had been appointed in January 2019, shortly before the election, by someone who became the leader of the opposition.
Well, it was that number 1, because that was clearly stated in the text in number 5. So what we're saying is that, consistent with the decision that was made from the text that you read earlier, we were looking in terms of making sure that the board was reflective of all of the initiatives and all of the items that the government had put forward. So we were looking in terms of the construct of it. And in that, these new persons, because at the time, they could not meet the board because the particular chairman's tenure was done, the deputy chair was done, and the board itself couldn't meet. So it was, and these three new persons who would not have had, who would not have met as yet, it was even more appropriate and fitting to relook. And as I said before, there are members of this cohort that were reappointed.
But your concern was that if you didn't act in this way by revoking all of the members and then relooking, is that you would have a statutory board that would not fulfill your mandate.
Well, it was actually consistent with what we said here in terms of what the government as a whole, cabinet as a whole, had actually decided.
No, I understand that. This was not a personal view. This was driven by cabinet.
Well, it was a collective view in terms of looking at all the boards.
Yes.
To make sure that we have, in terms of the mandate of particular government, and because there were ways in which the particular boards would have to be reaffirmed, and most of the members here were placed back on the board.
No, I absolutely understand that, and I'm sure Mr. Rao will come to it.
Yeah.
Because their membership was revoked. The reason for the revocation, according to paragraphs 4 and 5, is, it seems to me, is that you were concerned that if you did not revoke them and relook at them, you would end up with a board that would not pursue your administration's mandate. There's no reference here to youths or sister islands. This is the cabinet paper.
Yeah, but it has to be taken as a whole, doesn't it?
Well, the paper does, because it's your paper.
Yeah, but he took me through others. He took me through the ones for the premier and was trying to get me to confirm with what the Minister of Education was saying and what the Minister of Natural Resources was saying. So I'm saying is that it was all, we in government 45 days, 60 days and so forth. There was a decision made to look at the reconstructive of the boards. And those persons that, even though they were on the board, we were going to basically, Mr. Ken Hodge, he returned to the board. Eva and Vincent, she returned to the board.
But you didn't revoke Mr. Hodge, because he'd gone anyway by the effluxion of time on the 19th of March.
Yeah, but he was actually no, he was not revoked, but he was actually appointed.
I don't think he was.
But Mr. Hodge?
But we're looking at the
yeah, Mr. Ken Hodge. Okay, good.
We're looking at the revocations, and I know that some of these people were reappointed.
Yes.
But paragraph 5 comes over as strongly suggesting that the driver here was a concern that the board, if you didn't take action, the board would not pursue the new administration's mandate.
Well, we were less concerned in that, and to the point that we had a mandate. I was looking at the positive view of it. We had a particular, we had a new government, we had some specific innovative forward progressing, and the persons there. So you've seen the glass is half empty, I'm seeing it as half full, and I was bringing it up to full.
So we're both right, if that's the case.
Well, yeah, right, okay, fine. We could be deemed as both right.
Mrs. Rowett, sorry.
Just trying to keep it simple, and before we move on, Honourable Malone, this paper does not reference the matters that you've pointed to and we've looked at in the Premier's paper. It doesn't refer to the need for, if you could let me finish, it doesn't refer to the need for innovation, etc. What it comes down to is that what your concern was that 3 appointees still on the board had been appointed by the person who is now the leader of opposition. And the leader of the opposition would, according to this paper, be able to appoint 2 more people. The result would be that on that board, when it had its full complement, particularly if you only went up to 7, would actually have a majority of people on the board who had been appointed by the leader of the opposition. That was your concern, wasn't it?
You correctly took me through all of the other readings as to exactly what framed our minds in terms of the board verification. In addition to that, yes, the particular areas, because if you have 5 of them nominated, 5 persons nominated by the very same leader of the opposition, who was then the minister, then that will be not consistent with what the act was.
And so that's what you're saying, is that the reference to the balance envisaged by the Act is that only 2 people on that board can come from the leader of the opposition.
Well, sure, yes.
And so even though he might have appointed them when he was a minister, because he was now the leader of the opposition, your view was that he effectively had more than he was allowed under the statute.
Well, yes. Let's actually agree on that.
And your assumption at the time of drafting this, I know you're going to tell me that people were reappointed, but the assumption of this phrase is that because the 3 members had been appointed by the person who became the leader of the opposition, they would inherently
30 days earlier.
They would inherently be against your mandate.
30 days earlier. But I didn't say there was, no. That's when being against my mandate was not the overriding criteria here. I'm not sure, I'm being asked this about 12 times now. Being against the mandate was not the overriding criteria. I am trying to say to you that my glass is half full. So we look at it in terms of having the government's particular manifesto. I know it doesn't fit your narrative, but at the end of the day, this is what I am saying.
But it doesn't.
My narrative.
It doesn't fit paragraph 5. That's the problem, Minister.
I know, but if you look at the earlier readings in terms of,
I understand that.
Yeah,
you say this.
So if you look at this, because
you say,
I'm a sum total.
I'm terribly sorry, and I didn't mean to be rude. You're saying that this paragraph 5 has to be read in the context of everything, including that which Mr. Rawat has read out, and possibly some other things. But
yes,
is that fair?
Yes.
Yes.
It has to be read in context with what we, as a government, a new government, 7 out of 8 and 7 the first time, and only 1 member serving for more than 1 term. So I'm saying is that at the end of the day, this was what was sought, and most of the folks I know. So there's no. It doesn't go in context with what you are purporting. That is your context and not mine.
I'm sorry, Mr. Rawat, can I just ask one more question of this, putting this into context, because I understand that point. I don't think it's in this paper. Somebody will tell me if I'm wrong, and somebody will tell you and me if I'm wrong. I don't think this is a point mentioned in this paper, but in other papers about other boards, and I think in the Premier's paper, there was an additional provision which was agreed by Cabinet, that the appointment should be until the end of the administration.
Yes, it was written here. Sorry, not in this paper, but it was read out by Mr. Rebel.
Yes. And so that's part of the context.
Yes, that's part here,
yes,
in terms of this, yes.
Thank you very much, Mr.
I'll move on if I may. Before I do, Honourable Malone, I just want for the record to say I don't have a particular narrative to put to you. My role is to explore the evidence with you and to ensure that you are treated fairly, and I do that by putting propositions to you that give you an opportunity to answer and explain to the Commissioner.
Mr. Rawat, I'm just pausing only because of the stenographer.
Yes.
As you know, we have a stenographer,
sure.
And I think he's been going now an hour and 3/4, which is quite a long time.
Sure.
Is now a convenient time to have a break?
Yes.
We'll have a 5-minute break,
sure.
Minister, and then come back. Thank you very much. Good. Thank you, Mr. Rao. We're ready to go again.
Thank you, Commissioner. Honourable Malone, just staying with the document that we're looking at before the short break, I'm going to try and summarise it rather than read it out now. But what we see is that paragraph 5 had dealt with 3 members of the existing board, and at paragraph 6, in relation to Professor Joseph Frederick, it was noted he was stationed overseas and unable to physically attend meetings. And it was noted that the preference is to have members who are in a position to physically attend meetings and actively participate in the various committees of the board. And then at 7, in relation to Miss Alva McCall, that it notes that she's now working as a public officer in a capacity where decisions are made that could impact the Health Service Authority. And therefore, it would be best that she no longer serve as a member of the board. Now, pausing there, and I hope keeping it short, but the reasons that are set out there, and I will come on to the wider context with my next set of questions. But you've got at 5, appointment by the Leader of the Opposition as an issue. At 6, the fact that one member could not physically attend. And at 7, the fact that another member was working as a public authority. But it's right, isn't it, when we go back to the Act and the basis on which you as Minister could remove people from the board, none of those come within the scope of the Act, do they?
Except for the advice received otherwise.
Yes, I mean, I accept that your point is that there's a wider context. Yes. But my question is just directed to the Act. The Act doesn't give you a basis to remove the people that discussed in this paper for the reasons that you're given.
Another way, Minister, if I may, the power that you have to remove these people does not come out of this Act.
Well, yes, because the Act doesn't look in terms of the other advice on which we actually relied.
So, but the power, it may have arisen from somewhere else. I understand you say that it did, but it didn't arise out of this Act.
No. Okay.
Thank you very much.
If we turn to 3305 then, which is in the same paper, and the heading is legal implications. And it said there that no specific provision in the BVI Health Service Authority Act for the removal or revocation of the appointment of members of the board, but Section 20 of the Interpretation Act gives any person the power at that authority's discretion to remove the appointee. And it continues, as I pointed out in previous Cabinet papers bearing on the subject of revocation of appointments, the exercise of the discretion to revoke appointments must be in good faith, reasonably, and for the purposes of the Act. The reason provided in the Cabinet paper would appear to be a good basis for the exercise of the discretion to revoke. Was that the further advice that you were?
Yes.
It seems to be inconsistent with the wording of the Act itself, because the wording of the Act does provide a specific provision for the removal of people appointed to the board, doesn't it?
Well, that's a legal sentence that my legal.
With respect, it's not a legal sentence. It's what the Act says.
Okay, fine. I'm saying, but we relied on the advice given, and that's what we do.
Take it in stages. Do you accept that that's what the Act says?
That's what?
That this piece of advice is wrong because the Act does offer you a basis on which to remove people.
Well, I can't go and say the Act that the legal advice on which I rely on is wrong. I relied on this by the Attorney General.
So, can I just be absolutely clear? Because in the letter to which you very kindly responded in terms of criticisms, it said if there was a legal proposition that you relied upon, then you must provide legal submissions, and none has been provided. But what you're saying is that you had legal advice. You must correct this if it's wrong. But as I understand it, you're saying that you had legal advice from the Attorney General that there was no specific provision in the Act for removal or revocation of the appointment of members of the board, and consequently Section 20 of the Interpretation Act applied.
Yes.
You were by then, as you said, familiar with the Act itself. Because you
Well, as
confirmed
much,
earlier that
well,
you're
as
ready.
much as 45 days will give me, yes.
But earlier, the impression you gave, Honourable Malone, was that you were a diligent minister who would read papers and you'd make sure that you knew the basis on which you were
Well, it fit
making
the
your decision.
narrative in terms of what you were saying again, because I'm saying is that I said we were just elected in February. We weren't sworn in to the office of thing until March 15th. And here we are a few days later in terms of having this comes, but we read between that time that I was selected as Minister for Health, yes, we had to come familiar not only with this but all of the other authorities. So I am much more versed in the different acts in the ministry than I was 45 days into the ministry.
I understand that. Can you just help me with this? This is obviously your paper that we're looking at, and the policy decision. The policy decision is we're going to revoke the board and start again. That puts it fairly bluntly, but that's the policy decision. You then come on to legal implications of that decision. The decision is the recommended decision you've set out, and then you come on to the law.
Yeah, because we had to make sure that legally there was some legal basis on which it could be done.
Okay, no, that's a fair point. Thank you.
The memo is dated under your name the 7th of May 2019. My understanding of your earlier evidence was that by then you were familiar with your powers under the Act.
As much as 60 days can give me. We read it in terms of this specific provision because boards were up as a subject.
Did you at any time question, or did anyone question or raise with the Attorney General or draw the Attorney General's attention to the provisions in the Act by which you could remove a member of the board?
Well, I think that the legal implications were clearly stated here. He says that Section 20 of the Interpretation Act, Cap 136, is what we relied on in this particular instance.
But
no, as I'm saying, I agree. It's a legal point that.
I'm sorry, I was going to say something, and I do understand your view. You or possibly Mr. Rowett can help me with this. You've said you relied upon the Attorney General's advice. Do we have an advice or not?
Not as far as I'm aware.
Okay. Okay. No written advice, as I understand it?
Well, so sorry. The Attorney General in number 12 of this paper, 160-2019, when asked, because the readings that we had earlier stated to some concerns that were posed by the members of cabinet, and the legal basis when asked, he says, because I think you read it out earlier, that the Interpretation Act was actually relied on.
In relation to the tourist board?
Well, all of the particular acts, because it says, gives the authority which appoints any person. So I'm saying is that it is actually repeated here.
But it's repeated from the Premier's memo about the tourist board. Is that what you say?
Yes.
I see. Thank you. Could we move on then just to another memo? And it's dated the 8th of May, but it starts at page 3238.
3238,
please. It's a memo concerning the appointment of the chairman to the board. Do you have it?
Yes.
And we look at paragraph 4.
On 3239.
Yes, please. The proposal, in summary, was that Dr. Joel Stevens, a Virgin Islander who currently serves as an attending surgeon at Providence Hospital in Washington, is recommended to be appointed as chairman of the board. And you then go on in the memo to set out Dr. Stevens' professional background, and also note that in previous years, the last being December 2018, he had served as a member of the BVI Health Services Authority Board. What it doesn't say in this memo is whether you had taken account of the fact and of your view, your preference expressed in the memo we were looking at, that members should be in a position to physically attend meetings and actively participate on the various committees of the board. Because that was the concern about Professor Frederick. This memo seeks to appoint someone who lives in Washington, DC, as chairman of the board, but it does not address, does it, how that person can be physically present?
Well, maybe not in the board, but it is widely known that for years, because if you look at number 7, he was on the board there also. And what happens is that he is here every month of the year, because he's on contract and otherwise in the Virgin Islands. So maybe it isn't, it should have been more clearly stated, but he has physical presence here in the Virgin Islands every month.
It doesn't say it anywhere, does it?
Well, it may not be known to you, and it doesn't say it. And I'm saying at the end of the day, it was brought out, it should have been brought out more clearly. So on that, we agree. It doesn't say it, but it is clearly known that he is in the Virgin Islands every month on assignment, and he has physical presence. He had physical presence.
On assignment to what, please?
Well, because in the transplant business, he actually provides. He's a surgeon. He provides access to all the persons requiring, blood transfusion. Yes.
I see. And in terms of you say it was widely known that Dr. Stevens was in the territory. Widely known to who?
Well, the entire population, and the too many persons that have to have dialysis.
Okay, well, can we move on to 3243, please, which is another paper. We're taking them in chronological order. This is now a memorandum from your ministry dated the 6th of June 2019, Honourable Malone. And again, it sets out the powers that are available to appoint the membership. And then if we go to 4, what's said is that in addition to its ex officio members, the board is comprised of Dr. Joel Stevens, chairman, and Mrs. Helen Frett. Vacancies were created on the board following Cabinet's decision on 15th of May via memo number 160 of 2019 to revoke the appointments of the members of the board. And so it then puts forward 7 persons recommended for appointment as members of the board, all of whom have expressed their willingness to serve. And as you point out, and we see that at 6 and 7, 2 of those being put forward were members whose appointments had been revoked very shortly before. So can you just explain, please, to the Commissioner and just clarify the context, the process that was then undertaken? You had revoked 5 out of 6 members, all of whom had not reached the end of their terms. And you now were reappointing 7 people, focusing on the 2 who had been revoked, and that's Dr. Venson and Mrs. Kishel Blaze Cameron. What were the circumstances in which you came to reappoint them?
Well, when you look at, because in each of the persons, there are some specific criterias that you have to examine when you're looking at board members. Is the person dedicated and committed to the particular cause, the vision and leadership of the person, their ability to influence others, the straightforward and impartial, knowledgeable and quick learners, and dealing with discretion and confidentiality, all taken into context in terms of when you look at board members. So we had looked in terms of the resumes of these particular persons, because those persons who served before, their resumes are on file. You can look at them and then you can see them. The other persons, they, although there was no quote unquote formal interview, but they would have been called, they would have been asked in terms, well, they would have been known in most circumstances in terms of the different profession. The ministry itself would make recommendations. I would flag persons, we would debate them within the ministry, and you'll see whether or not they're the persons that fit the overall mandate that the government had actually set forth.
Again, I'm sorry to interrupt. You've rightly pointed out that the leader of the opposition could nominate 2 members, yes, under section 5.5. Were Dr. Benson and Mrs. Blaise Cameron his 2 nominations?
One of them were, and then he had another nomination. So Dr. Benson was mine, Dr. Blaise Cameron was his.
Did he have a second nomination?
Yes.
That went through? Who was that?
I can remember. I think it's Andrea Walters in 3247.
You've explained the exercise that you went through as the process of reappointment. And you've explained the consideration that was given, for example, to Dr. Benson and Mrs. Blaise Cameron. Why couldn't you have done that before revoking? If you had their resumes on file, why couldn't you have done the exercise rather than going through the process of drafting a memo, taking it to cabinet, revoking their appointments, and then reconsidering it all again?
Well, it is a matter of style, is it? So we had looked in terms of doing it in that particular fashion and look afresh at everyone.
That's right. And you use the word "we," and that was the policy, wasn't it? Revoke everybody on the board, yeah, and then, as it were, have another look at the constitution of the board. Thank you. And
to give it its context, look at we looked at Memo 103 of 2019 and the context there as to what the old administration, sure, wanted to do. That provided you the framework with which to assess who you would then put forward again for appointment or reappointment.
That's correct.
The last part of this, if we just to complete it, if you go to 3249, please.
3249.
That is the beginning of a cabinet meeting number 14 of 2019.
Yes.
And 3271, if you do that. We'll see there that the paper that we've just looked at was then taken by you to cabinet.
Yes.
Part of the deliberations begin if paragraph 59, if we look, cabinet noted that the proposed member, Mr. Lemuel Smith, is currently employed as the manager of Caribbean Basing Enterprise / CBE Engineering, a private company owned by the Minister for Health and Social Development. However, the cabinet was content to proceed with the paper and the recommendation. And what happens if we look at 372 is that the upshot of what cabinet decided was that 6 people would be appointed there was a deferral of Mr. Klein, who was proposed not just as a member, but deputy chairman. That was deferred for 2 weeks, but essentially your recommendations were approved by cabinet. That's right, isn't it?
Save for the one. Yeah.
For Mr. Klein, and was that after 2 weeks? Did he ultimately become the deputy chairman?
No.
Of what happened there then?
Mr. Ken Hodge did.
I see. Right. I've checked back across the table provided by Ms. Bertie, and that's right. So did that then require a new process by which you then had to produce a new paper and put Mr. Hodge before cabinet again?
I'm trying to remember the process there. May have, but I'll have to confirm that. But his resume was on file, and his all of his details were there.
I mean, the purpose is not to delve into why Mr. Hodge was a better candidate than Mr. Klein, or why Mr. Klein didn't, but it's just whether, when you're if Mr. Klein is no longer going to be the deputy chairman or a member, you need another member. And does that still require you as a process to have to ultimately take it back to cabinet?
Yes.
Just to touch on Mr. Lemuel Smith, cabinet, you had made the recommendation, and presumably when you made the recommendation, you knew that Mr. Smith worked for a company that you owned.
Yeah.
So at that point, in considering his nomination and making the recommendation, did you see any conflict of interest arising?
No, he was the best man for the job. He has served on the board prior, and from all of the interactions with the persons that he had served under, he was doing a remarkable job, and they were yearning for him to be back.
Who were yearning for him to be back?
The executive and the persons at the HSA.
I see. So the sort of people behind the scenes, the secretariat, if you like, looked forward to Mr. Smith coming back on the board. And again, he would be someone that you, having done that process, concluded was someone who fell within the framework of let's call it the Premier's memo, the intention of what you wanted to do in terms of your program as an administration.
Yeah, they were quite pleased of him coming back on the board.
Just to be clear, I think I asked you a different question and you've given an answer to an earlier question. I mean, I take the point you say that people were pleased that Mr. Smith was returning to the board. He'd last been a member of the board in 2016.
Yeah, I think that
that's in your memorandum. Your paper has to summarize how people see these and produce them. My question was, did you see him as someone? I think the answer must be yes, because that's what you explained earlier.
Quite keenly, yes.
You've gone through this assessment process, and part of the assessment process looked at where people sat within the framework identified in the Premier's memo. That's right, isn't it?
Yes.
Thank you. Now, again, it's something I think I may well have asked you this when you came the first time, Honourable Malone, but at 59, there is a potential conflict identified because cabinet is voting to approve someone, and that someone happens to be employed by you. How did you deal with the conflict in this circumstance?
Well, all depends on what you call the conflict. The conflict was in terms of family members and so forth. I'm not sure if in any writing, anywhere, anytime, it says that if a person happened to have been employed by you, that it cannot be considered.
Well, that's a fair point in terms of the cabinet handbook, but my question goes to a wider point. Here you are recommending someone to be on a board that sits under your ministry, and that person will be paid a stipend. He will make decisions that involve the use of public money, and he works for a company. He works for you. Now that, in the public's eye, may create a potential conflict of interest. Did you not appreciate that it might be a potential conflict of interest?
Well, for the purpose of which he was going to be employed here, and I'm saying it is, as you would clearly state later, there was nowhere and where it states that someone who is employed by you cannot be engaged, especially if there's a person's best suited for the job. And Mr. Smith was best suited for that task.
From your perspective, no conflict even arose because he wasn't a family member. He was just an employee.
Yes.
Thank you.
And tomorrow he could be not an employee also.
Last bundle we need to go to this afternoon, Honourable Malone, and that's back to part 1, please.
Sorry, this is bundle 1.
Bundle 1, please. And if you just turn up page 257, please.
Bundle 1, 257.
It's just really to ask for an update, please, Honourable Malone. 257 is a table that forms part of the second affidavit that Ms. Bertie has provided. You'll see from there, it gives us the composition of the board, and the board that we have been speaking about, the appointees we've been speaking about are listed there. So you'll see Ms. Smith, and as you rightly pointed out, and I wrongly tried to correct you, Mr. Hodge is there as the deputy chairman.
Sometimes you're wrong.
Very rarely.
Well,
but if we go then on further,
but always fair.
Not sure. It might have been Mr. Hari assisting.
Sorry, I was saying, but you're always fair to the witness. That's the important thing.
Okay.
I'm grateful for that. But I just wanted just if you could update the commissioner, please, Honourable Malone. You see that aside from Ms. Smith and Mr. Hodge, the other members of the board, including Mr. Smith, who we've been talking about, had appointments for 2 years, and those appointments expired on the 21st of June, 2021.
Yes.
So what is the current position in relation to the board?
The board is fully filled now. I think the new chairman was brought before cabinet first.
On what date? Can you remember at all?
That I would have. Let me see how best I can bring that forward. I have to get that. I think it was because he was brought before cabinet. He was carried before the House of Assembly, and all that.
What? I won't ask you to guess, Honourable Malone.
Right. I'll get the date.
I think the one thing we've learned from our hearings is that we ought to try and give people as little homework to do as possible.
Yes.
But if you can give the commissioner the current composition of the board and the dates on which they were appointed,
sure,
that would be helpful.
And please, the length of the appointment.
Yes, it's all 3 years now. The new ones are for 3 years, but we'll get the exact. You'll get the exact. Let me see if no. Okay, none of them are here. So
No.
I mean, in fairness to Ms. Bertie, her affidavit was actually prepared on the 18th of June. Therefore, yes. So changes hadn't been put in place.
So you have the ask. Okay, fine.
Thank you very much.
If you are happy to make a note of it,
yes.
So that's new board, when were they appointed and what their terms of their length of appointment is, that we won't then write to the Attorney General to remind her. But thank you very much for doing that, Honourable Malone. Can I turn to the last matter that we need to go through today, and that is the written response that you have provided to the potential criticisms that were raised in a letter from the Commission. It should be, unless you have it in the file of papers that you've brought with you, there's a copy on the table.
Well, I just sort of walk through it, but I'll use your copy and I'll make sure it's the same.
Well, use whichever copy you find you're most comfortable with, Honourable Malone. What I'm going to try and do is take you through it without without repeating too much of the evidence that we've gone through with you, because you will have answered some of these criticisms already in your evidence. But I think it's important to get it on the record, in fairness to you. The response helpfully sets out, first of all, the potential criticism, and then underneath it sets out the response in bold. Do you see that, Honourable?
Yes.
Now, the first one deals with the revocation issue, and we've gone through the detail. And so if you're comfortable, I won't set out that detail, but I'll take you to just signpost some of it as we go through. And that's, if you look on the second page, what's said is that it appears from the evidence that the reasons given for immediate revocation of the membership of the board was insufficient. Firstly, because the Act deals with the possibility of changing governments through the imposition of term limits, meaning that the revocation on the basis of that three members had been appointed by the leader of the opposition when he was in government is unnecessary. And also it notes that section 551 of the statute does not say that the leader of the opposition is entitled to have 2 people on the board. What it says is that the leader of the opposition is entitled to nominate. Whereas just to remind you, your paper said that the leader of the opposition is entitled to have 2 people. The second point,
if I may.
Yes, I think it's in fairness to you, if you want to answer on that point.
Well, are you saying that we're quite generous in making sure that they have 2 persons? I think it's fair and proper to do.
I'm not criticizing your decision to read the Act as allowing the leader of the opposition to appoint 2 people to the board. What was being pointed out to you in the letter was that the Act, on its wording, allows the leader of the opposition to nominate, not to appoint.
I see.
What's also said at point 2 is the reference to that the reason given for Professor Frederick, which was that he could not be physically present, was at odds with the fact that Dr. Stevens was appointed despite working overseas in Washington. I think that's a point that you've dealt with.
Sure.
And then the third one is that, which again is a point that you've dealt with, and we've looked at, is that the revocation of the members of the board was not for any of the reasons that were set out in Schedule 1, Section 3 that we've looked at.
Sure.
And so the criticism that's made is that firstly, by revoking the membership of the board, so effectively removing all of the members with one exception, that failed adequately to provide for independent expertise and oversight of the board. And the second is that the policy of revoking the membership of statutory boards with every new administration, which is something that you've explained to the Commissioner, fails adequately to provide for independent expertise and oversight of all such boards. Now, I think if I develop that a little bit, would you accept this? The consequence, if you remove every member of a board, you lose the cumulative expertise of that board and you have to start all over again.
If they were not reappointed.
Yes, of course, if
none of them were
if you reappoint some people, then that you ameliorate that. But that is a risk, isn't it? That
well, yes, yeah, one can say that.
And in this situation, was that a risk that you considered worth taking?
Well, no, I didn't take it because I reappointed those that were there.
Well, and was it a risk in your mind then at the time?
Not necessarily. I said, in my mind, there were those that were reappointed. So it's a risk that I did not take.
Yes, and I mean, with respect to the question, these members that we're talking about were only appointed in January.
Yes.
And I think you said that they possibly hadn't even been to a meeting by the time of the election. I mean, and it doesn't matter, but their experience was very short. That was the only point I was making. In terms of the proposition Mr. Browett was putting, which is loss of cumulative experience, at least in respect of those who were appointed in January, the loss was relatively small.
Well, it could have happened, but in the circumstances, no, only because Dr. Stevens had served before, Lomeo Smith had served before, Ken Hodge, was it his very first? I'm not sure if it was very first, but there are a number of persons. Benson had served prior, no, so there were a number of persons. So I did not fall into that risk category.
Thank you.
And if I just then summarize your response, and I hope that's you're okay with that, Honourable Malone, because as you've confirmed, you're content and for the Commission to consider the whole of the response, and he will do so. But what you've answered there, it was government policy to reinvigorate board appointments generally. You go on to say that the board illustrates the flexible approach taken with that policy, as demonstrated by the reappointment of some members to the board. And you then refer to the memo, and this was one that we looked at, the changes were made in an effort to maintain an effective and well-balanced board in furtherance of the aims of the Act, and you point to the Attorney General's advice.
Can we just pause there for a moment on that last sentence, because this is one which at the moment is concerning me a bit. My understanding of your evidence ministry is that the Attorney General advised in respect of this board. Well, let me give you an open question. How did the Attorney General advise in respect of this board? In writing or how did?
No, because when the Premier's paper came up earlier, it was raised.
But that was in respect of the tourist board, which...
No, what I'm saying is all of this board, because he had sent a number of boards, because in the particular paper with the Premier, there were 2 or 3 boards, I think, that were things. So there were some boards that were earlier. And this was a matter of concern. So
was the advice that the Attorney General gave, that advice, the advice that found its way into the Premier's paper, he didn't advise specifically on this board?
No, because once it was given, just like every, well, even of this particular act, of the COI Act, precedence goes a long way, doesn't it?
No, I understand the point, but your evidence is that the attorney advised before the Premier's paper, if we can put it like that, and what's set out in the Premier's paper is set out in the Premier's paper. My recollection, we can go back to it if necessary, is that advice was given in respect to the tourist board, where there was no express provision in the Act for removal of members. And just before you respond to that, that seems to be reflected in your memo to Cabinet. We've been through it a number of times, paragraph 12 on page 3305, which starts, there is no specific provision in the BVI Health Services Authority Act 2004 for the removal or revocation of the appointment of members of the board. Because my understanding was that was a premise of the advice the attorney gave in respect of the Premier's memo.
Okay, yeah.
Yes. Where I struggle, because as you say, you or I think it was you, took that advice and applied it to the health board.
Yes.
Is this. The Act, which is a short Act, has a section headed removal from office, and that's paragraph 3 of the schedule, which sets out the provisions by which a member can be removed. And therefore the premise of the advice, the earlier advice, which is that there's no specific provision in the 2004 Act for the removal of members, the premise of that advice is not met.
No, well,
But
I'm not sure how many ways I can say this, except for the, the legal arguments can be made. But at the end of the day, I am saying that it came up as relates to boards, and the Interpretation Act gave a premise on which it could be viewed. Whether that is right or wrong will have to be argued with the particular attorneys.
And this isn't a criticism,
Sure.
but no legal submissions have been put in on that point.
Well, maybe we should, yeah.
But I'm not sure it matters, because whatever the advice was,
yes,
it was based apparently on the premise that there was no specific provision in the mother statute. Because that's what you say in your note. There is no specific provision in the BVI Health Services Authority.
But that's not a complete sentence, is it? Sorry,
yeah,
a complete paragraph, is it?
There is no.
However,
there is no specific provision in the BVI Health Services Authority Act 2004 for the removal or revocation of the appointment of members of the board.
yes.
It does go on to say then, however, section
Yes.
20 of the Interpretation Act. But you say you simply took the advice of the attorney and adapted it and applied it to the circumstances of this act.
Commissioner, if I may possibly help on this, I think maybe the process of how the paper is compiled and who drafts the legal implication section, I believe it may be the Attorney General that drafts that specific provision, but perhaps the witness may shed light on that question in terms of how the document is prepared.
Well, certainly if it would help. Minister, can you tell us how this part of the document was prepared?
No, sorry, this here or in terms of 160? Memo 160?
Paragraph 12 on page 3.
Yeah, 160.
Yes, you need to go back to part 3.
Page 3305. I'm sorry to
Part 3?
Part
Yes.
3.
Yeah. But as you're aware that legal arguments I always leave to legal scholars.
No, quite right. But
yeah,
this at the moment, this isn't
it's not legal.
No, it's not legal.
I see.
But firstly, Mr. Harris suggests that it would be helpful if you told me.
And go to where now?
Page 3305.
33.
I'll let you get there first.
Yes. It's quite voluminous, these.
Yeah.
3305. Well, this is way back, okay. Yes. The entire paragraph has to be read, and this is what I'm doing.
No, before you do that,
yes,
because I don't want to stop you doing that. Mr. Harris suggested it might be helpful
yes,
if you told me how this paragraph in your note came to be produced.
Well, what I remember, this would have been 29 months ago, we had a new government. We had a specific mandate. We were looking in terms of making sure that we look at the particular boards, those members who had all of the criterias that we had set out, both in the act and in terms of their particular commitment, their vision, all of the other stuff that can bring this to this, including the youth part of it, the sister island part of it.
Yes.
And it says, like in the tourist board, what reliance legally would you have in terms of the revocation of any of the
members?
Yes.
Yes.
And number 12 could not be more clear.
Well,
there are no specific provisions in the act. However, section 20. So if the legal scholar was wrong, then I was wrong, but I don't know if he was wrong.
But it is clear, but it's clearly wrong. I'm sorry, not as a matter of law,
Yeah.
not as a matter of law. The sentence, there is no specific provision in the Act for the removal of members. That's what the first sentence says. Where there is paragraph 3 of the schedule is headed removal from office. How can that not be wrong? I just don't understand it. Because the advice you're given, frankly, is only as good as the instructions that are given to the legal advisor.
Well, one can say that, but at the end of the day, those are legal points. You might say they're not legal, but to me, they're legal in terms of what we relied on. I can only tell you what we relied on. And in fact, he finished it up. The reasons provided in the counting paper would appear to be good basis for the exercise of the discretion to revoke.
Yeah.
So
if the cabinet had discretion, that might be right. It might be right.
okay, fine. What I'm saying is that.
But you say it's a legal point.
Yeah.
Now, the letter that was sent to you saying that if you were going to raise any legal points, they had to be put into legal submissions with your response. No legal submissions have been received.
Okay, well, I guess there'll be homework number 2 on that one and so forth, and making sure that
but
done.
Not homework for you. That's homework for the Attorney General. But I would like, please, any legal submissions that the attorney wants to make on this proposition, that in the face of paragraph 3 of the schedule to the 2004 Act, that's the BVI Health Services Authority Act 2004, which is side-headed removal from office, that is, of members of the board, that as a matter of law, it can be said there is no specific provision in the Act for the removal or revocation of the appointment of members of the board. And that's, as you say, that if you say that's a legal point, then we'll get a legal submission on it.
Commissioner, may I come in on that, please? Because I believe what the Honourable Minister was saying is that as a factual matter, he relied on the advice of the Attorney General. The matter of law was a matter for the Attorney General to advise on. And as per his submissions, also in writing, Cabinet was entitled to place reasonable reliance on that advice. So with respect, I'm not sure it's so much a legal point that was being made as a factual one of reliance on the authorized legal officer and their advice.
Well, Mr. Higher, can we come back to that at the end? Because that may mean that I'll review the direction. But shall we finish with the Minister's evidence first and come back to that? And then we can deal with it in one way or another. But thank you for raising it. Yes, Mr.
Let's turn back to the written response that you've given.
Which one?
It's just the letter on its own now.
Very good question, though.
Second.
There we go. We were on. I think I can summarise the points that you make in the response, Honourable Malone, because you have developed them. So you, as we say, and this is the point that the Commissioner asked you about, you rely on the fact that the Attorney General had given advice. You then point out to the fact that you say that because Dr. Venzen and Mrs. Blaze were reappointed, the practical effect was that of that reappointment was that the BVI HSA board was not revoked on a wholesale basis, but you say rather particular board members' appointments were revoked for reasons that were set out in the cabinet paper. And you then conclude that the reappointment of the existing members was consistent with achieving a balance of expertise on the new board. You've given the Commissioner further context about that process anyway. You then, if we turn over to the next page, again, return to the Attorney General's advice, and you conclude, as Mr. Hyries pointed out, the Cabinet was entitled to place reasonable reliance on that advice. And you then say, no reason to suppose that new members, with the inclusion of some of those who'd previously served or otherwise, could not provide effective and independent oversight of its management and activities. And you refer then to the fact that, and you give two examples, that's Dr. Stevens and Mr. Smith, that they had previously served on the board. You say there's no evidence that any of the appointees are not independent or that they lack expertise. Their resumes were exemplary, and it's not understood from the potential criticism to be suggested that any nominee is not well qualified to carry out the role. And then the final point you make is a point you've already explored today, and that is the availability of Dr. Stevens to attend meetings. If I then go on to criticism number 2, and this is something that we have explored with Miss Bertie as the acting permanent secretary, and I hope if I just try and summarize it, the criticism was in effect of the process. So matters were not done, like, for example, you did not have a competency profile, you did not advertise the positions, the process was entirely internal, there was no candidate interviews, and the point was also made, the conclusion was that no reference was made when appointments came back to Cabinet to the fact that Dr. Venzen and Mrs. Blaise Cameron's appointments had been revoked less than a month earlier. And the concluding compendium point is made that it follows that no reasonable effort was made to identify and select the most suitable and qualified candidates for membership of the board. Again, if I try and summarize, I hope fairly, your response to that, you point out, Honourable Malone, that it's not been the practice of successive governments over many years to advertise vacancies on statutory boards or to hold a formal interview process. What you say is that ministries and departments have invariably applied the criteria that are specified in the relevant statute. And I pause there. We've looked at the 2 statutes for the boards that sit under your ministry, and I've taken you to the provisions that describe the kind of knowledge and expertise that you as a minister must have regard to. You point out that the small size of the Virgin Islands and of the suitable pool of possible candidates, you rely on those, and you say that then desk officers and permanent secretaries in the ministries and departments have been used to holding informal discussions to identify willing candidates of appropriate standing and then discussing them with you as minister. And you would discuss them with your colleagues, is that right?
Yes.
Do you yourself approach potential candidates?
Sure.
Is that for what purpose would you approach a potential candidate?
Well, first of all, first in terms of the willingness to serve, number 1. Number 2, in terms of any potential areas that might cause them not to be able to serve. And I've had, in filling other committees and boards, I've had situations where I may well have, well, not may have, I brought forward a name and the officers say, well, look, this person served 2 or 3 times before. Number 1, they've said that this person may not be, you might want to reconsider looking at this person because of point A, B, and C. So it was not everyone brought forward that was accepted. So too, even at the cabinet level, as with Mr. Klein, you'll see that he was brought forward all through the ranks because he too had served before. But but it goes through this, and when it goes to the House of Assembly, again, it is another. Well, for the chairman, it's another checkpoint for this. So these appointments are not, come off the street, here you go, and this is it. It goes through a number of checks and points and so forth. And I'd like to state something clearly that, especially with this section of criticism, it was quite difficult to fully appreciate, only because as I had mentioned, and I might want to invoke or put into the record the statement I read when I first came here, because I am of the opinion, again, that the total review of governance in the BVI for the past 70 years may not well be, and it is not a bad thing, but in the context of a commission of inquiry, I still have my views on it. But these processes that we looked at is what has been, what has attained since 1967. Senate is an institution of ministerial government. These are how boards are chosen. These are how it is done. I could say the same thing for the 1880 Act. I think that the Commission of Inquiry is operating under. They all need to be reviewed. We have brought monies in to have this done. So this particular review is good in that context. And I think it should be looked at, as the Attorney General will tell you, that monies have been put in place to have a review of all of these acts. And in fact, in the Ministry of Health, we have made 2 specific posts available. The substantive permanent secretary, she's now an advisor to bring all of the acts and laws and regulations and statutory instruments for the social development side of it up to par. The other one is done in terms of the health advisor. There's a post that I will fill to bring all of the health acts up to date, because most of them are too old. So we have to get them up to date.
Yes, thank you.
If we move on then, I mean, again, summarizing it, but what you point to, because the potential criticism was about the process, and what you point to and rely on is the fact that there is, whilst there are informal discussions, there is an internal process by which people are recruited. Sure. If I take you over to the next page, you then say that
in which section?
Again, it's the same one, but
okay, fine, good.
If I just want to try and summarize your response for the record. You say that it's always lain within the responsibility and power of the governor to instigate a change in the standard practice of public officers and the advice given to ministers on such a subject. And you then say that the newly elected and appointed cabinet was not then advised by the Attorney General. The governor or the deputy governor's appointments should be advertised and candidates interviewed, or that the long-standing approach of the public service they inherited and the advice to ministers in making such appointments should be replaced by a wholly new system. You then go on to say that it was only in May 2020 that the governor, who was well aware of the existing practice, suggested a shift to a more transparent process. But you say then it was that suggestion was in relation to leadership posts such as the chairman boards. You then say that the government fully accepts that the appointment process requires modernisation, and you point to measures that are being brought in or encouraged to develop a process of advertising, interviewing and ranking candidates for the membership of the board. And then you return to the reappointment of Dr. Venson and Mrs. Blaise Cameron as consistent with achieving a balance of expertise. If I take you to the third potential criticism that was raised, and this points not just to Mr. Smith, but it's that no conflict checks were carried out, and that the procedures set out of paragraph 6.8 of the cabinet handbook were not followed. I won't take you to the handbook unless you need. I'm sure it's something you're very familiar with. What you say there is that the steps contemplated by paragraph 6.8 were not ignored. Candidates were asked at the time they were approached to ascertain their willingness to serve, and officials were mindful of the need to avoid such conflicts when considering the suitability of a candidate. When you say the officials are mindful of the need to avoid such conflicts when considering the suitability of a candidate, are you speaking there specifically about the May 2019 process?
Well, in terms of the ministry's staff, when they look at this, the candidates themselves, in terms of areas of where they may not, by virtue of some of the conversations that we have, not be able to serve as a matter of conflicts, then that is more in line with that. The officials here will be the officials of the ministry.
Yes,
Yes.
no, I accept that, but the question was specifically, the potential criticism put was in relation to the 2019 appointments that we've looked at. Mr. Smith, Dr. Venson, etc.
Right.
My question was just that when you say that officials are mindful of the need to avoid such conflicts when considering the suitability of a candidate, did you have that particular process in mind, or were you speaking more generally?
Well, it was more generally in terms of what creates a conflict of interest.
You then continue to say that the cabinet memorandum, and we've looked at that, sets out the information that would be required by the handbook and the considerations that paragraph 6.8 mandates. So you say that that's when one looks at the cabinet memorandum and considers the informal process that was operating in the ministry, that the procedures set out in paragraph 6.8 was satisfied. And then you return, I think, Honourable Malone, to the question of Mr. Smith, which is something that you've already addressed to the Commissioner. But perhaps it's important just to kind of make the point that you make at the end there, where you say his appointment was on the basis of his exemplary services rendered on previous BVI HSA boards. I'm sorry.
Again, in addition to all of this, we must take it in context. We were elected in February, appointed as ministers in March, had the first sittings and all, and then coming through with getting all of this pulled up to date. If I may be assertive enough to say, as opposed to looking at only the areas of criticisms, would the Commission be minded to look at areas in which we did it good?
Of course.
Okay, fine.
But in terms of, yes, of course. But in respect of statutory boards, where all of the members, I think in all of the boards pretty well, their memberships were revoked, and then there was a very big process to replace them all, albeit with some reappointments. That was, of course, a burden which you shouldered.
Yes.
It was government policy to sack all of them. Members of all of the boards.
Reconstitute.
Reconstitute,
yes.
Is a better word, but it's a much better word.
Same effect.
Same effect.
A full FMT.
Yes, Mr.
Commissioner, I hope I've taken through the Honourable Malone through his written response, and I think we've got to the end of that, and he'll no doubt be relieved that we've also got to the end of my questions for him today. But so can I conclude, firstly, by thanking the Honourable Malone for making time to come to the Commission and give his evidence, but also for the way in which he has given his evidence.
Thank you, Mr. Wright. Could I just ask one more question, if you'll forgive me? Miss Bertie referred to both the board and the committee as autonomous bodies, i.e. autonomous from the ministry, standalone bodies. And she accepted that autonomy is reflected in things like the tenure of office, which means that members can only be removed on specific grounds. Do you agree that they're autonomous bodies?
Yes.
Thank you, Minister. Thank you very much for your evidence, which has been very, very helpful. And thank you also for your, particularly for your time. I know that you have many, many other obligations, and your time's very much appreciated. I've got the one point to do with Mr. Hirey. You can go or stay as you wish, but thank you very much for your time and evidence this afternoon.
Well, I'd like to thank you very much also in terms of this and the question that, well, in terms of the statement I made and the first thing, being a part of this record, is that asking too much?
I'm sorry, I
had made a statement, a written statement submitted when I first appeared.
We've got everything that you.
Okay, so
you've
and I can make this part.
No, we'll take everything that you've said and sent into account. Yes.
Thank you.
Yes, thank you very much. Do you want to stay or go, Minister?
Mr. Harry, do you need some help?
Minister, please, by all means, take your leave if you need to. I'll respond to the issue as it arises.
To him otherwise.
Okay,
That's
right.
super. Thank you very much.
Thank you very much, Minister. I'll just let the Honourable Malone go, and then I'll just deal with this last point.
Okay, thank you very much.
Mr. Hari, it's a sort of narrow point, but it may be an important one. And that's the point that arises out of paragraph 12 of the Cabinet memo on page 3305. My understanding of the Minister's evidence, which I think you indicated might be wrong, my understanding was that he said that the whole of this paragraph, including the first sentence, was advice. But my understanding from your intervention was that you considered that the second sentence was, the second and third sentences were advice, and the first sentence was a factual matter. But what submissions do you want to make on that, Mr. Hari?
Yes, no, thank you for the opportunity to clarify, because I think that might have been a misunderstanding of what I was intending to say. What I was intending to say is that, as I understood the Minister's evidence, it was that, as a matter of fact, he relied on the Attorney General's legal advice with regards to the lawfulness of the revocation. And that is a different point, of course, from the issue of law and whether the Attorney General necessarily got it right or not. So I think that the point that was made is that he and Cabinet were reasonably entitled to rely on the Attorney General's advice. It was not for them to advise the Attorney General on law, and they did rely on his advice.
Sorry, fully understand that, but that wasn't the point that I was niggling at, and that is the first sentence of paragraph 12 says there is no specific provision in the Act for the removal or revocation of the appointment of members of the board. My understanding of the Minister's advice was that that was legal advice that he received from the Attorney General. Is that right?
I believe, I have no reason to disagree with that. That is the advice that was given, so it would seem.
So the Attorney General advised that there was no specific provision, despite the fact that in the Act there was a provision headed removal from office.
That's what the document says.
No.
Yes. Yes. Well, that's how certainly I read the document, and I believe that's how the Minister understood it.
Okay. Final point, just before we let you off your homework, Mr. Hari, because I am anxious not to give you work that is unnecessary. But do you accept that the first sentence is patently wrong?
I mean, I think we've been through several times today. Mr. Rao has gone through the provisions A, B, C, and D. So there are provisions in the Act that address the issue of revocation of appointments. I think that the Interpretation Act is also something that the Attorney General had referred to. I think it wasn't pulled up by Mr. Rawat today, but it was referred to by the Minister. And I think that, in the context of that provision, the advice was given. The Attorney General may, in giving the advice with regards to specific provisions in the statute, it may not have been correct, but it does seem that that's the advice that was given alongside the Interpretation Act reliance point.
Can I just repeat the question, Mr. Hari? I'm sorry to do so. Do you accept that the first sentence is patently wrong, that there is no specific revision in the Act for the removal of members of the board, given that the Act has a paragraph in the schedule headed removal from office in respect of members? If you think that a justifiable proposition under any circumstances.
I'm sorry, Mr. Commissioner, could you start your question again? There was overlapping.
Certainly. If you consider that there is any possible legal basis for the first sentence in that paragraph, then I'm afraid I'm going to have to ask you in writing to set out what it might be. I simply, as a matter of fact, I cannot understand it. That's my problem.
Yeah, no, and I understand, Commissioner, the point that you're making. There are provisions in the Act, we've seen them, that deal with the revocation. So I don't disagree with that. I think that the advice was what it was, but I don't disagree with what you say and the provisions we've looked at, taken on their own terms.
Thank you very much, Mr. Hirey. Nothing else from you, Mr.
Elf, and we will reconvene tomorrow at 10 o'clock.
Yes. Thank you, Mr. Howard. Thank you, Mr. Hirey. We'll stop now until at 10 o'clock tomorrow.
Thank you.
Thank you.